And three, does it serve the ends of justice? There's a provision for you may well take that view when your lordship is sending a which when your lordship is sitting in court. Consolidation. But when it's an arbitration agreement and someone hasn't signed it, and you haven't chosen an institution which allows for consolidation or joinder, but there is consent. When you're sitting ad hoc, accepting a settlement, can you just bring in an ad hoc situation? Because if I say take the ICC rules, or if I take the CIAC rules, or if I take the MCIA rules, or the DIEC rules in Delhi, and I can choose any of them, there's a provision for consolidation, there's a provision for joinder, which means I have consented to consolidation, I have consented to joinder. And in those circumstances, yes, multi-party disputes may well be joining one, but there is consent by accepting a settlement intention, but not in an ad hoc situation. And that's really where 73 becomes tricky. The court will have to lead to greater uncertainty. And 76, and the reason why I say it becomes a bigger problem is that when it talks about the mother agreement and subsequent agreements, it has a fundamental bearing on interpretation of contracts and the point of time and decipher intention. Let me just read out 76 and then highlight the two problems. Paragraph 76 of Cloro reads the court will have to examine such pleas with greater caution and by definite reference to the language of the contract and intention of the parties. In the case of composite transactions and multiple agreements, it may again be possible to invoke such principles and accepting the pleas of non-signatory parties for reference to arbitration. Sorry, just from the second sentence it should have been in where the agreements are consequential and in the nature of a follow-up to the principle of other agreement, the latter containing the arbitration agreement, and such agreements being so intrinsically intermixed or interdependent that it would be their composite performance which shall discharge the parties of their respective mutual obligations. This would be a sufficient indicator of intent of the parties to refer signatories as well as non-signatory parties to arbitration. The principle of composite performance would have to be gathered from conjoint reading of the principle and supplementary agreements on the one hand and the explicit intention of the parties and the text of the agreement on the other. Both paragraph 73 and 76 are inconsistent with the two fundamental agreements. 73 permits a non-signatory to be roped into an arbitration agreement merely on the basis that there is direct commonality of subject matter and the agreement between the parties constitutes a composite transaction that is insufficient to justify consent. 76 is consistent with the basic principle that intention of the parties to an agreement must be determined not only from the text of the agreement but also from the date of its execution. If on the date of its execution there was no subsequent agreement, then it would not be envisaged that an arbitration clause in a mother agreement would bind a subsequent agreement unless so expressly. That's when your doctrines of incorporation, etc., will come in. Suppose if I have signed an agreement on the 1st of January 2023, and it's a long drawn contract, suppose I sign another agreement on the 1st of January 2024, and that either has a separate dispute resolution clause or has nothing. There have been many cases like this. From a contractual interpretation perspective, how can you say that your mother agreement, which is 1st of January 2023, envisaged agreements can come back, that subsequent disputes in a subsequent agreement will be covered by the That could never be the intention of the parties unless it was expressly provided. Saying all the future contracts or all disputes arising out of future contracts will also be part. Because it's a separate contract.
Mr. Diwan,
And it happens.
that point is well taken.
There have been many cases like this.
All those
And Fluoro was a case like this because in Fluoro, the finding is subsequent agreements.
Now, move further.
Disputes under subsequent agreements can come back to the mother agreement.
What is the
And those physiological defects in Fluoro had their own arbitration cases. Very good. How would that be the basis to decipher intent? Because when the mother agreement is
you get that point, Mr. Diwan, that point is well taken. You don't need to labor on that. All those passages in Fluoro and subsequent, the point is well taken. You have understood your point. Now, move further. Tell us which is what is the method? What is the process by which we would arrive at the actual consent that you are propagating?
I think you have para 31, 28 and 31.
Very good. So I will skip.
Let's go to
I'll skip a couple of paragraphs. 21.
Now come to 28 is where you quote
fundamental.
So 21, 23, 25 my respectful submission points in the fact. And that's the same kind of problem. Just one greater concern which arises at paragraph 20 of ONGC where it is said, it noted that written intention paragraph 25 classes can extend to bind non-signatories with the where target the credit-worthy member of the group of companies.
These paragraphs allow non-signatory to be bound without consent would make them inconsistent with the fundamental facet of arbitration, can only be resorted to with the consent of the party.
And that little part that I wanted to refer to from ONGC, which is problematic in my respectful submission, is that paragraph 30 of ONGC, where it is said, it noted that written intention to arbitrate between parties can extensively bind non-signatories with the aim to target the credit-worthy member of the group of companies.
This is what read, which you have quoted yourself.
I have this.
Then exactly we have referred to Redfern, we have quoted Redfern there.
That's why I'm not saying I'm not promoting.
Where you have referred to Redfern yourself.
I certainly have.
Redfern expressly refers to
Thou for us
purpose
is
of
not
the
the
doctrine.
statute.
That's right. Now, paragraph 27, your lordships is absolutely right. I have referred to Redfern and how Redfern reads down now.
In fact,
That's right.
And what Redfern effectively was a paragraph 27. I mean, what I've said out of paragraph 27 says this.
according to the Dow chemical case may perhaps be best characterized as authority that conduct can be an expression of
Now,
consent,
as being a group of
and that
companies,
among all the
read
factual
now
elements,
in
the
what it
existence
really
of a
should
group
be.
of
Thou
companies
for us
is
is not the
So deeply
statute.
obliged. So deeply obliged.
Correct.
That's what
Not just a statute, but in other words, go by section 7.
In fact,
what the law is.
and in fact,
The lordships has
at
Redfern.
page 11, para 27.
But am I asking your
0.54.
I've highlighted.
According to the Dow chemical case may perhaps be best characterized as authority
There is a little balancing.
that conduct can be an expression of consent, and that among all the factual elements, the existence of a group of companies is irrelevant.
I'm so deeply obliged. So deeply
How to
obliged.
really then
That's what I highlighted to your lordship's time consideration.
what kind of
Now,
conduct?
your
what
lordships
kind
has
of
all of
consent
these.
or implied,
Your lordships has Redfern, which I have quoted more than instance. But am I asking your lordships to just simply subscribe to what is set out in it? And my respectful submission here is just, there is a little balancing that's required. And that balancing is what I have said at paragraph 20.
Para 20.
And there, Manoj, I will give
Now go to para 31. That's where your 2 points which you are making. How to really then infer what kind of conduct and what kind of consent or implied term.
Because one is that, then towards the conclusion, Namrata, I give you a lot of stuff. Because can I read out 20? Because there's something critical there. Because there's a little balancing that's required. It is respectfully submitted that the evaluation that is to be conducted, sister,
Para 20.
that is the evaluation to be conducted. Presumption must be balanced. These are the presumptions which have been drawn by Redfern, not to be with the equally compelling, which at the point of execution of the contract, that the party who has, and that's the point. When your lordships has documents such as
But therefore, are you saying that basically
not to be
no
bound
party
by the
is not
arbitration
signatory to a contract
by having the
can be bound by
contract
the arbitration?
executed through a subsidiary or a sister concern. The action of stepping away and limiting liability may well form the basis to demonstrate an intent not to be bound by the arbitration agreement, which at the point of execution of the contract has been accepted by the party. And that's my point. When your lordships has documents such as...
But therefore, are you saying that basically no party which is not a signatory to a contract can be bound by the arbitration?
No, there may be some circumstances where you may have accepted.
Obviously.
Where you may have written, but today there is no such. Don't just look at it. Your lordships balance the evidence. But if there is no evidence, suppose I have negotiated the contract. It happened when it's all but finally signed by my BVI subsidiary. The counterparty has been perfectly happy executing the contract with the BVI subsidiary. I am using my group structure.
That I consent to
Shielded
move
us.
away.
Am I not entitled to do so as long as the contract is correct?
So we are talking about
Why
determining
should
the
that-
consent. There we can easily.
I'm the sugar. Of course, it was found. Yes.
So that is what we have.
But it's a
to
high
sort of
speed trade
focus on.
happening
Yeah,
with my people. That's it happens all the time in India. I'm
Precisely, Mr. Diwan.
What is it by reading all of these decisions?
Party or a
I can
group
tell you what
company
this
can
looks like.
arrange their affairs in a manner that I consent to move away
These decisions
particular
are being
part.
read to
This is
say
what you are trying to say.
that's correct.
So we are talking about
You're performing
determining the consent. Then
That's
we
only
can
a subsidiary.
easily see.
Your role.
There was
That's the
to
concern.
move away.
Yes.
So that is
And
what we
nobody
have
is looking
to
into
sort of
the fact
focus
that,
on.
yes,
In a situation.
That's right. I get back and you
guys are arranging that.
I'm so deeply obliged. What is step? And step by reading all of these decisions.
Para 34.
Yes, I can tell you with some amount, with some experience that I have with this. These decisions are being read to say, yes, it's a composite transaction, you're performing the contract, that's only a subsidiary, you're wrong. That's the consent. Set out in the consent to arbitration. And nobody is looking into the fact that, yes, of course, I may have negotiated, but I step back and you perfectly well agreed to allow me to step back and step out of dispute resolution perspective from the doctrine of separability. Yes, let me straight away come back. And what is also set out by test.
34, 35, and 36.
Yeah,
you have laid down the
test.
Yes,
Suggesting
so look, the test I and General Gerald itself, so wait till the last one, from it would US conscious set out in the consent to act by the government. And anything which effectively says there must be a clear and unmistakable intent to arbitrate. And the letter would not. This must be from a dispute resolution perspective from the doctrine of separability. And what is also set out by Dalla in the concurring opinion of Lord Collins at paragraph 122, where it was right at the end of paragraph 30, what your lordship should see the last lines. It would have to be a conscious, deliberate act by the government. That anything less will be a deliberate act of the government, make it less relevant. This was the government of Pakistan, and the letter would not be relevant.
Para 31, there's two tests.
I said out in the additional skeletal submission to paragraph 7.
One there.
I'll come to it. The conduct of the, and these are exceptional circumstances, bound by the arbitration as a separate. And you can get me in document and get me in contract, but if my disputes will you can't, you will be arbitrated. So these and
must be para 34,
an implied term in contract where a non-signatory is implied to be a party to an arbitration agreement. These are the two bases which if clarity is brought out here as part of section 7, will make it significantly easier. And these are exceptional circumstances. And there is something which I the NABA power penta test, and you can get me in. Get me in. But if you can't, then you can't. So these and
must be para 34, 35, 36 is important actually.
That's so look how I have now distilled section paragraph of the Arbitration Act. The first of which is the I just read out the first part I in 7. It says arbitration agreement. So this part arbitration, that's the first part. And the second by the parties to submit to arbitration or all the which have arisen or between them in respect of a defined. In these proposals, I divide that part of section 7 into to an arbitration. There are odd sections of the Act. I'm reading paragraph 7, which is whether the first of which is the agreement by the parties to submit to arbitration certain disputes. So that's the first one. The second part of section 7 relates to the manner by which such disputes will arise under a defined legal relationship. So that's how I believe these proceedings. And binding a non-signatory to an arbitration agreement ought to be the definition of a party ought not hinder your, which is whether there is an agreement by the parties to submit to arbitration. It is only on the conclusion of such inquiry that the basis and substance of the dispute which may have to be arbitrated are required. And therefore, the paragraph 36, I say, if in a particular case it has to be a certain. So that's how I break section 7. And what I also must further submit is that it is paragraph 35 is that the definition of party ought not hinder your yes. Because there's a party point, I will say what should be the real party. Because 218 says unless the context requires otherwise. But please, so your lordship is not bound by just the definition as it stands. And therefore, the paragraph 36, I say, if in a particular case it has to be a certain real party to the arbitration agreement is a non-signatory, or in the definition of 218 ought not come in the way of restricting the arbitration only to the signatories.
Now just let's see your conclusion, Mr. Diwan.
Yes, no, just the little point of claiming through and why you filed against
through and under, it's okay,
Mr. That's it. I'm not going to repeat anything. But please remember just one with somebody who's a signatory. When the section 8 and section 45 come into it's a direct 845. I have filed a suit in India. Very exactly. It can only be related to an Indian suit or any other Indian proceeding. Non-signatory to come in and accept a non-signatory comes to arbitrate because the other person claiming through an under. Why is it filed against me? Yes, I am claiming through and under against this as a defendant. Send me to arbitration because there's an arbitration agreement with somebody who's a signatory. Certainly the signatory comes no difficulty. It's a direct 845. Says no, I'm claiming through and under is actually a defendant's job. I am the real party. Send me to arbitration. It's meant for a non-signatory to come in and accept that obligation to arbitrate. Because the other person who's filed a suit says, yes, I may have a contract with which is person X, maybe you're the assignee, maybe you're not the assignee, I don't know, maybe you're the parent company, I can't go against it. I file a suit, and the point was, parent company comes and says, no, I'm claiming through and under my subsidiary. That this honorable, I am the real party. Send me to arbitration because your contract has. So it's a defendant's doctrine, and what I'm only saying is this: that defending the doctrine under 8 and 45 cannot be used to just bring a non-signatory in arbitration, which is where there's been a conflation in my respective situation.
All right, let's go now to the conclusion.
No, that's certainly not. On the execution, and the point was it is respectfully submitted that this honorable court, as well as resolution to set aside parts of the decision in development of arbitration and subsequent judgments that allow arbitral tribunals to commence arbitration only on the basis of the GOC doctrine. Under the GOC doctrine cannot, without more, extend an arbitration agreement to a non-signatory. The determination of the real party to an arbitration agreement must be reflected on the execution of the arbitration agreement of disputes. This joins the public policy between certainty of contracts as well as resolution of disputes and are not antithetical to the development of arbitration. And therefore, that is because there are other recognized doctrines on the basis of which multi-party disputes can be resolved under the broad umbrella of a single determination. These include concepts such as recognition of a single arbitration clause, doctrine of incorporation, or in the case of institutional rules, provided for consolidation of disputes. As Hanashra notes, joinder and consolidation of disputes is an issue distinct from the issue of extension of an arbitration clause to a non-signatory. And therefore, the policy consideration for contract becomes very important. The two mullahs should not be conflicted. Yes. And I've quoted this. And that is unfortunately what has happened with Proro and with judgments which have gone down. But I want to answer one question which Manoj Justice Roy had raised, not today, but a couple of days. Such a situation, from a construction contract, composite transaction, employer, contractor, subcontractor. Mr. Kambata has made certain submissions, which I can group you in. But under the FIDIC rules of contract, which again internationally for contract becomes very, very important. So the construction industry will also, and I've quoted this. Article 4.3 says that the subcontractor has no privity with the employer. The way now, if your lordship's clause under Indian law says sorry, such a situation, and because of composite transaction, because at the end of the day, subcontractors are only performing for a contractor who's performing for an employer, I can group you in.
Thank you, Mr. Diwan.
Then it's going to be against the FIDIC rules of construction contracts. So the construction industry will also, in my respectful submission, gets into a bit of a TC. So let's take international trade. The way companies are set up for international trade and commerce, again, provides
Anybody else?
And therefore, I would be very hesitant in accepting, as the other side says, Proro in its entirety. And the judgment.
Thank you, Mr. Diwan. I think thank you very much, Mr. Diwan.
But I'm also deeply obliged. With all my references, I'll just take one. I'm not going to make a take my first skeletons and my additional skeletons, and we will make a reference to everything that is relevant.
Thank you, Mr. Diwan. Anybody else? What is 5 minutes? What is covered so far? Yes.
But go ahead, 5 charts.
Where were you all through?
Charts, all right. Give us
Response number 1 and 2.
How will you be able to argue? You don't have any idea of what has happened before you
no idea.
matter.
No, I've been watching the proceedings.
They wouldn't have missed you.
You are watching on the virtual mode or physical mode?
But physically and as well as virtually, whenever I could not be here. I
What is the point you want to make here? What is covered so far?
But I just made 3 charts if Lordship permit me.
Charts, all right. Give us the charts.
But I just wanted to, my lord, just put some. But I just wanted to just place before Lordship just the elephant on the table, and this, unfortunately, I don't have solutions, but I was raised certain important issues, my lord, the Lordship to consider. But one is, my lord, which fell from my lord Justice Narasimha on the very first date of the hearing, and which my lord the Chief Justice picked up on the issue of parole evidence. That, my lord, common law jurisdiction, my lord, we go by there is an aversion to parole evidence, and we go by. But I just want to just place for lordship just the elephant on the table, and unfortunately, I have solutions, but I was raised certain important issues, my lord.
Yes.
Consider. But one is, my lord, which fell from my lord Justice Narasimha on the very first date of the hearing, and which my lord the Chief Justice picked up the issue of parole evidence. That my lord, common law jurisdiction, my lord, we go by evidence. There is an aversion to parole evidence, and we go by what is Section 11 the written document. And therefore, my lord, we come to Section 7 of the law. Now, my lord, the difficulty comes, my lord, when we come to my lord 8, 11, and 9. Because the difficulty will be, my lord, that when there is certainty in Section 7, that we know those A, B, C, D, E, and they are all written. It may not be a written signed document, but there are exchange of parts between parties, written evidence. The Section 9 judge, Section 8 judge, and Section 11 judge has clear, my lord, yes, my lord, evidence before it, primary evidence before it. Yes. Now, my lord, what happens, my lord, when you don't have that, and you have to go beyond the written, the world? My lord, that is why the difficulty will happen, my lord, if this group of companies doctrine traverses beyond Section 7 concepts. My lord, for example, Char case, my lord, it took 3 years and we suffered an interim order. So much so, my lord, there was a restraint on alienating assets.
So, what would you like to, how do you formulate your submission?
Yes, my lord. My first
points so that you can just take them down.
Yes, my lord. My first proposition, my lord, with lordship will see from the chart which I have given the first chart. My lord, what the group of companies doctrine does is it conflates, my lord, two contrary concepts. If lordship sees the chart, my lord, and I have given at the first paragraph, my lord, is called the which requires presence of wrongdoing, and the second column is absence of wrongdoing. Now, my lord, Professor Gary Bond calls the first one non-consensual, meaning, my lord, that there is requirement
to formulate it.
May I formulate that? Concept of alter ego. My first proposition is the group of companies doctrine conflates contradictory propositions of law and hence is unworkable.
The concept of alter ego.
Concept of alter ego, my lord, is based on wrongdoing. And there has to be egregious fraud or some kind of sham.
Which are those contradictory propositions?
Some kind of wrongdoing. If lordship has my first chart, the concept of alter ego.
The concept, we are taking it down now. The concept of.
Well, I can submit for me. I can give submissions later. But the concept of alter ego is not so much as
the concept of alter ego.
The concept of alter ego, my lord, is based on wrongdoing. And there has to be egregious fraud or some kind of sham, evasion, some kind of wrongdoing has to be there, my lord. My lords have in several cases explained this, including, my lord, the recent case in Balwant case, lordship. And here, my lord, dealt with this issue. And lordships have explained, my lord, that it is the intent is not so much as whether you are intending to be bound by the arbitration agreement. There has to be some element.
One is alter ego.
Alter ego. Second, sham, obligation, evasion of statute, facade. And my lord, I've given the judgments where my lords have in several cases explained this, including, my lord, the recent case in Balwant case. Lordships have, my lord, dealt with this issue, and lordships have explained, my lord, that it is not just having a tight controlled company or closely held companies. There has to be some element of fraud. There has to be some intent to avoid obligation or to defeat a statute or evade payment of tax.
All right, there's the first proposition.
Yes, in contrast, my lord, Professor Gary Bond says that this is non-consensual, meaning that even if you did not intend to be bound by an arbitration agreement, if your intent was to avoid and evade, then you're still bound. And he, of course, applies the group of companies doctrine and says that in such circumstances also a non-signatory entity is bound by the arbitration process.
All right, there's the first proposition.
Yes, in contrast, my lord, lordship sees even if there is no the other, my lord, commonality of subject matter, existence of company, group of companies, composite nature of contract, performance of contract, single economic reality. These what lordships have over time, my lord, etched out as attributes of group of companies doctrine, my lord, are all not based on wrongdoing.
positive wrongdoing.
It's simple. That, for example, in MTNL Lordship said if there's a tight economic structure, even if there is no wrongdoing, even if there's no evasion, even if the intention is not to avoid the group of companies, and you're bound. And if 7 is absent, now, Manoj, the difficulty is, as I was saying, my lord, cannot bring in such.
We got that. Yes.
This section.
So what you're really saying is that the whole concept is intended to reach out cases of fraud, positive wrongdoing.
I'm obliged.
These aspects which have been highlighted in chloro, they really are not based on wrongdoing at all. You may have a composite contract, you may have performance by one of the obligation of another without any.
I'm obliged. And if 7 is absent, my lord, if the 7th test is absent, you cannot bring in such.
We got that. Yes.
That's all. Well, the second, my lord, related to this, my lord, and this is the issue. Coordinate judges have taken control. Of course, I'm trying to pitch it at a level, but I don't know whether lordship will accept this. But what I'm submitting is that even with regards to, and this is where lordship will have to reconcile, because I've given the contradictory judgments of all the high courts, my lord. Will not even when it comes to egregious fraud or alter ego piercing, competence, Honorable High Court of Delhi and Honorable High Court of Bombay and Honorable High Court of Madras have taken contradictory views. Coordinate judges have taken contradictory views, and I've given the table in the third table. I will not read it, my lord. But cannot pierce the corporate rails. And that an arbitral tribunal, being a creature of a contract or with a specific remit, will not have the plenary powers of the court. One of these judgments are in the post-competence, post my lord's thorough control. The learned judges are aware of all this. Yet they hold, my lord, and that court, an arbitral tribunal being of limited jurisdiction, cannot pierce the corporate rail. And that can only be done by a court of plenary jurisdiction. I didn't want to waste lordship's time by going through my submissions, but I've extracted those parts. Just to name a few judgments. My lord, in the Delhi High Court, my lord, I've given in the third charge, Sudhir Gopi versus IGNU. My lord, Justice Bakru's judgment is there. And my lord, Bombay High Court Justice Gupta's judgment of NOD Bearings Private Limited, I've given as serial number 3, my lord, of the third which they can do it. So my lord, my lords will have to reconcile this. I didn't want to waste lordship's time by going through my submissions, but I've extracted those parts where the discussion is there, and the High Court says that it cannot go. The tribunal cannot pierce the way. So my lords will have to reconcile this, and of course, lordships will hold one way or the other. That whether this group, I've given also the other judgments which are held, they can do it. So my lords will have to reconcile this issue, or it has an effect at rest. And the other is when there is the last thing I would submit, my lord, and which I was submitting on Vidyat Rolia, and I've done in both these circumstances. In Vidyat Rolia, my lord, lordships have, my lord, made the it's not an exhaustive list, but lordships have given certain exceptions to arbitration.
In the case of
now, two exceptions, if I may, based on the lordship's consideration. One is when there's an adjudication at rem, or it has an effect at rem. And the other is when there is a statutory machinery provided for the adjudication. And lordships have in both these circumstances, it is out. The arbitral tribunal cannot enter into this domain. And I have given in that second charge,
first instance, in the case of in them would be a probate.
I'm obliged.
The second would be surface, where there's a
deeply obliged. Or in my case, I would submit if lordship considers the Companies Act. Because in the Companies Act, and I've given the sections in the second charge, all the provisions are there for inquiry and investigation into the character of the company. Now, would lordships, my lord, permit a tribunal, which is a creature of two parties, agreeing to an arbitrator who may not be a trained lawyer? There is no obligation. As lordships said the other day, it could be a technician, it could be an engineer, an architect. Would lordships say that the power which is vested in a tribunal by the statute of determining who is the controlling authority, would that be given to an arbitral tribunal? Ultimately, certainty, which is the issue. I'm obliged. I'm so sorry, I interrupted.
Thank you. Light away. That is thank you, Mr. Gochi.
Can I have just
yes,
coordination committee for respondent number 1 and 2?
But 1 second, where is George Posen gone?
Yeah,
there you are.
Now my lords have the benefit of.
Are you wondering where is suddenly disappeared? You're disappeared behind the scenes.
Doctrine and arbitration and the various views across the globe.
My lord, at the outset, I appear to mention that ancestral is not per se for India and IA number 69863 of 2023. Non-signatories to arbitration, corporate structuring. This is what ancestral is
for the National Coordination Committee
of ancestral. The mandate of ancestral, that is the United Nations. Having heard the arguments at length, now my lords have the benefit of hearing both sides, ensuring the views of both sides on the issue of group of company doctrine and arbitration and the various views across the globe. International trade law. My lord, at the outset, I would just like to mention that ancestral does not per se have a development of company doctrine, but looks at non-signatories to arbitration, corporate structuring. This is what ancestral has looked at. Give a note after this, my lord. I'm just skipping the mandate of ancestral. That is the United Nations Commission on International Trade Law encompasses promoting ways and means of ensuring uniform interpretation and application of international conventions and uniform laws in the field of international trade law, collecting and disseminating information on national legislation and modern and legal developments, including law in the field of international trade. The model of complements the new.
You have a note? Give us a reading.
I'll give a note after this, my lord. I'm just skipping most of it, was already covered. I'll prepare a note with comparative.
What is the? Tell us. Just formulate what your point is, George.
My lords, I'll just draw a comparison between the Indian Arbitration Act and the ancestral model law. The 2006 amendments to the ancestral model law. The reason for the amendments is clear that, and I'll also touch upon the New York Convention because the model law complements the New York Convention. And my last point would be on arbitration without privity. Amendments to accommodate non-signatories to the. In this regard, it's pertinent to note that the Arbitration Act of India is based on model law, and there is reference to that in the preamble and in the statement of objects and reasons of the state. I mean, it's so the legislative intent is clear that the Indian model law.
So where does UNCITRAL stand? UNCITRAL stand on the group of companies doctrine.
My lords, the UNCITRAL has brought about the 2006 amendments to accommodate non-signatories to the arbitration. Like this, I'll just.
Where do we get? You're standing on the wrong side.
Sorry?
Standing on the wrong side.
Well, I mean, it's non-signatory is not a group companies doctrine. That's why I said it's.
So that will be better,
I mean, neither here nor there, but I'll just put it across what exactly it's.
I don't know how many countries have accepted the 2006 amendment.
Yes, I'm coming to that.
Into account other this thing, but so you can just consolidate and sort of reduce the note and then give it to us.
Yeah, a lot of it was repetition.
Mr. George, why don't you give us a note on this? Because
I'll give a note on this. I'll just quickly go through the. Yes.
Because that will be better. We'll be able to then see how it has evolved.
Yes.
Perhaps you have prepared a note.
Yes.
Which also takes into account other this thing, but so you can just consolidate and reduce the note and then give it to us.
Yeah, a lot of it was repetition of what
that is what. But trying to avoid that, so in your note, just delete the part which had been covered by the others.
Yes.
And focus on UNCITRAL.
And right now, just sort of formulate your points. And you can give us a note. So just in 2 or 3 points that you want to make, you can tell us. Take it down.
Yes.
Is there any suggestion that you have or
amended in 2006
idea
in order
that
to
you
respond
want
to
to
concerns voiced by an increasing number of scholars, practitioners, and judges who are of the view that if your lordships could have volume 1 of my compendium, page 33.
Just formulate it.
I'll just practices. It was pointed out by practitioners that in a number of situations, the drafting of written documents was impossible or impractical. In such states the reasons why the amendment was made. Article 7 was amended in 2006 in order to respond to concerns voiced by an increasing number of scholars, practitioners, and judges who are of the view that formal requirements set out in the original version of Article 7 should be amended to better conform to international contract practices. It was pointed out by practitioners that in a number of situations, the drafting of written documents was impossible or impractical. In such cases where the intention of the parties to arbitrate was not in question, the validity of the arbitration agreement ought to be recognized. On the arbitration without
George, you put all this in the notes. Make it a short 3 or 4 page note and give it to us.
Yes.
We'll have a background of why the 2006 Act model law, why the model law was amended in 2006.
Yes.
How many countries have accepted the broadening of the definition in the arbitration agreement?
And yes,
can give it to it. Let's call upon the other side so that you can
just touch upon 2 points and just on the arbitration without privity, because I mean, Dala and those chemicals have been dealt at length. So I'm not I'll not touch upon that once again. But on Article 7, my lords, if I could just
George, give us a note. Just give us a note.
Sure.
Very, very, very brief. I am for respondent number 1 and 2 in 5101.
Ms. Arora, you're on the right side, right? George was on the wrong side. I hope you're on the right side.
I am on the right side. I am
Right side in the sense that you are supporting the group.
I am supporting the arguments that have been advanced by the learned Solicitor General and Dr. Singhvi. And I support the
George, give us a note.
group of companies.
Just give us a
to be
note.
read in.
Sure.
I only have very, I am for respondent number 1 and 2 in 5101.
Ms. Arora, you're on the right side, right? George was on the wrong side. I hope you're on the right side.
I am on the right side. I am
Right side in the sense that you are supporting the group of
I am
companies.
completely supporting the arguments that have been advanced by the learned Solicitor General and Dr. Singhvi. And I support the principle of group of companies to be read in. I only have a very brief, let me just make
Tell us your
it
point.
very clear. My lords, first of all, I have heard whatever I have stated now. All these matters, Mr. Devan has appeared for respondent 9 in 501.1. I believe Mr. Darais Kambata has appeared for respondent number 8 and Mr. Ghosh for the petitioner. Now, what's significant in this matter is that this matter does not arise out of Section 11, it arises out of Section 9. And Section 9 is very distinct and different from Section 8 and Section 11 because Section 9, while the court may have applied the principle of group of companies to pass an order restraining the parties because of the very nature of the contract, but Section 9 principles are entirely different from that of 8 and 11. The arbitration, my lords, by various orders, it has now been held that third parties. So therefore, the arguments that have been advanced, and I believe it was suggested by my learned friend that the issues are different and can be that I only want to put this on record in the matters final order of grant of interim relief, setting aside the interim protection and preservation. My lords, before I have during judgments, under the arbitration and also after the award till such time as it is executed. So therefore, the arguments that have been advanced, and I believe it was suggested by my learned friend that the issues are different and should be detailed. I only want to put this on record, lest the final order deal with setting aside the interim protection granted by the High Court. My lords, I have placed the judgments under Section 9.
So, which is your matter? This has to be
My
dealt.
lords, this is McLeod Russell versus KKR India, where everyone seems to have expressed an argument on 8 and 11. My lords, it is, it's 501.1, it's 8607 of 2020.
The most we hear, we will take it that arguments were addressed on
Now, my
the
lords,
general-
I am grateful. I need that clarity.
Before the regular.
I needed that clarity to be in because I didn't want to be faced with an order suddenly setting aside an agency protection.
We're not deciding individual cases.
Yes. Now, my
He made that point,
lords,
Mr.
is
Kambata in fact
based
clarified that we were only arguing on law.
of
And
very-
all of us have been only arguing on law. None of us have really gone, I mean, your lordship haven't even touched the facts in McLeod.
Now, my lords, coming down to very briefly, and I will just take about 5-7 minutes of my lord's time, no more, because most of the judgments have been read, and I'm not going to read it except to the extent it may be absolutely necessary. My lords, the entire principle of group of companies is based on an aspect of the subsidiary, as my learned friend argues, is protection holding companies, subsidiaries, etc., which may be within the group. From the arm of the it is well recognized in the matter of corporate structuring that very often there are companies which have no or little assets, and a holding company may be the one which will hold all the assets, and they may be only leased to the subsidiary, or it may be vice versa, and that is to ring fence and protect yourself from the arm of the law in the event either the subsidiary or one of those group companies gets exposed to liability. That is a principle my lords will find in respect of structuring of the holding companies or the group companies very well settled. Because the idea is a protection.
Argument has been that, look, short of a case of egregious fraud, these are structural arrangements which the law does recognize.
I have no issue with that. They may be done for the purpose of taxation, they may be done for whatever reasons, ring fencing, protection. I'm not on that aspect at all. But I only want to restate the principle when I show the judgments, whether it comes from chlorocontrol, Trevon, MNL, and the last one in ONGC, that the court reaches out on what was your intent, was what, as it was argued just a few minutes earlier, was it your intent that I'm not going to allow an exposure of my assets into this contract, or did you conduct yourself in a manner which was representative to the other party, entering into the agreement that yes, the other companies within the group will stand for the liabilities, obligations under the contract. That will be the test.
Yes.
And in that context, if we start from chlorocontrol itself, if my lords, may I not take you to the judgments? If my lords have the written submissions filed by my colleague, I just want to show the few words that what will be that nature of conduct, intent, reflected from the facts, which will bring large group companies to the
Yes.
We say a lot about non-signatories to be taken out. 501.1. That each one of the judgments says, and therefore, if I have that context clear, so each one of these judgments only signifies that what will be that nature of conduct, intent, reflected from the facts, which will bring the group companies into the purview. We say a lot about non-signatories to be taken out. The principle is that each one of the judgments says non-signatory. Would my lords group companies? So the question of signatory does not arise, because if they were signatories, they were automatically bound by the contract and the arbitration provision. Because they are non-signatory group companies, therefore the various principles have been set out in each one of the judgments. Just few minutes and I will satisfy that. My lords may mark the word. My lords have my submissions. Would my lords turn to page 17? First of all, chlorocontrol. I'm only going to read few lines and few words and phrases in them, because my lords have already read these judgments extensio. I'm not going to take again. Please remember, my lords have page 17. This is a part of paragraph 72 at the bottom of the page. Clear intention of this evolves a principle that a non-signatory party. Now, my lords may mark the word. First of all, we are understanding that the party is a non-signatory, could be subjected to arbitration, provided these transactions were with group of companies, and then, my lords, the principle is set out in chlorocontrol with great detail. Please remember the principles on the holding, subsidiaries, assets to be there or not available. The clear intentions of the parties to bind the both. So therefore, first thing that the court will look at, was there an intention? What are the factual backgrounds to establish that intention? Both the signatory as well as non-signatory. In other words, intention of the parties is of significant feature. So the principle that the court said was intention. Now, my lords, please, page 18, 3 verses in 103.1. But the court sets out these principles. So these principles have actually been laid down. The first theory is that of implied consent. So the court will look into the facts to see whether there was an implied consent. Did you participate in the negotiations? Did you make representations at that time? That yes, this will be done through a subsidiary? Are there back-to-back contracts where you took a subcontractor to execute your contract, but he is not a party to the main agreement, etc.? So, my lords, we have to look at each one of them. Next, third-party beneficiaries. Simple classic example in 501.1. A loan of 100 crore each is advanced. to two companies which have no assets. That loan, they are only the companies which take the monies and pass it to the other group companies, etc. So those two companies take 100 crore each from respondent number 1 and 2, pass it on to their other two companies. Now, there are orders which have been there, their representations made. Those companies will not pledge their shares. Those companies will not alter their status as being into public listed company. They shall maintain their EBITDA, etc. Who has made the representation? The parties that hold 49% odd shares in those companies. This is a conduct, this is a beneficiary, this is an implied consent, guarantors. Assignment and other transfer mechanisms of contractual rights. So this is the principle that Fluoro Control said. We will look at these factors to see whether these non-signatory third parties are assenting to will be parties to the arbitration. Now, my lords, very quickly to Charan, if my lords may come to page 19. Would my lords just come to the highlighted portion? In holding, my lords have that, in holding a non-signatory bound by an arbitration, the court approaches the matter
these are extracts from...
My lords, yes, these are paragraphs. What I am only trying to establish before the court is that each one of these judgments set out a principle or a circumstance where it believed that in these particular fact and circumstance, a non-signatory group company would be amenable to be joined as a party to the arbitration, whether it was Charan or for that matter, MPNL.
These are extracts from...
My lords, yes, these are paragraphs. What I am only trying to establish before the court is that each one of these judgments set out a principle or a circumstance where it believed that in these particular fact and circumstance, a non-signatory group company would be amenable to be joined as a party to the arbitration, whether it was Charan or for that matter MPNL and subsequently ONGC. And in each one, my lord,
we've been very conscious not to
principle or a test which is laid down.
Other submissions are there.
So, my lords, that is my principle in terms of understanding the principle of just quick subsidiary, management of fencing, protection.
We've looked at these judgments, and we'll also note here that this particular matter 9, NHS section 9, no question of detagging because they're not going to decide on this at all.
Because in fact, that submission was made, and none of us have touched the facts. Because in fact, we've been very conscious not to touch the facts.
Yes,
we have your
other submissions are there.
So, my lords, that is my principle in terms of understanding the principle of a holding subsidiary, management of ring fencing, protection. Then what are those aspects that the court will look into? My lords will find it here. The only judgment that hasn't been set out here is that of ONGC. Yes. And my lords, in ONGC, I would request my lords to look at paragraphs number, just give my lords paragraph 37 onward until 41. Because principles in all these have been set up, then culled out as to where then have a non-signatory third party joining in an arbitration. So my lords, to say that Section 7 requires it in writing, etc. The principle is entirely different. In what circumstances would you have the non-signatory? My lords, paragraph 37 onwards until 41.
Okay.
And those same principles have been then culled out as to where then have a non-signatory third party joining in an arbitration. So my lords, to say that Section 7 requires it in writing, etc. The principle is entirely different. In what circumstances would you have the non-signatory?
Thank you so much.
Now, And my
Not that
lord,
there
the
is work
only
will
other
expand
thing
to
is
fill the
that
time available
this
to do it.
particular
Actually have more
reference
time.
will not apply in case of
whatever I
section
did
9
before
because I'm
That
not.
you have already,
That you have said.
Not
Please
under
clarify.
that principle, it's entirely different from 7, 8, and 11.
Yes, thank you.
Great.
Ms. Dr. Singhvi, how long will you take?
Since your lordship has a special bench at 2:55, I have to finish before that. I'll finish. Your lordship has a, not that this work will expand to fill the time available to do it. I actually have more time. I need whatever, I'll finish before your lordship's bench. It'll be faster. If the courtmaster can put three things. One is my note, which I gave you lordship in the opening. Lordship will call it note 1. One is a rejoinder note I have given now, which is a pointed one. Argument this, answer this.
Right.
And third is CL1. That is case law 1. There are also case law 2 and 3, but these three will cover 95% of my note. So my argument is simple.
Just broadly, what is your submission going to be, Dr. Singhvi?
It'll be faster. If the courtmaster can put three notes, three things. One is my note, which I gave you lordship in the opening. Lordship will call it note 1. One is a rejoinder note I have given now, which is a pointed one. Argument this, answer this.
Right.
And third is CL1. That is case law 1. There are also case law 2 and 3, but these three will cover 95% of the time. That's the correct. Simple. Now, obviously, that's your lordship has to really ask three or three basic questions. I'll take only a minute. One, wrongdoing will display my intent. Well, as I say, the learned friend says, life law is not logic but experience. And so, if your lordship were to go strictly by group companies to arbitration without your lordship, cannot have anybody not sign going to arbitration. That's the correct way to look at it. Now, obviously, that's not what a lordship is. Look at those 10 tests and fines. Where is intent? There is second error. Only wrongdoing that the entire display my intent. Settle the dispute to arbitration. My learned friend says, there is wrongdoing, positive or negative, you will send it to arbitration. Can't you have an intent to go with your sister concerns group companies to arbitration without wrongdoing? Third, but if the shield is made to as though you have a ring fence, then if the lordship applies any of those 10 tests and finds A, that there is fragmentation. Your lordship finds that the entire intent to settle the dispute to arbitration is frustrated by two companies being out because it is ring. So your lordship's doctrine is a superimposed doctrine which goes, of course, to the true intent, but along with intent sees all the other intents which are already given. That's going to be our broad. proceed quickly after a few minutes. I'll proceed quickly to give a few minutes to one and
one part of Ms. Arora's statement, because she's here for the first time. One aspect I need to respond to. I need about a minute, not more.
Now, so therefore, Lordship will have these three things open: my original note, my rejoinder note, and my CL1, which is case law 1. Proceed quickly after a few minutes. I'll proceed quickly to give a few minutes to one and
one part of Ms. Arora's statement, because she's here for the first time. One aspect I need to respond to. I need about a minute, not more.
Now, so therefore, Lordship will have these three things open: my original note, my rejoinder note, and my CL1, which is case law 1.
1 minute.
Which was repeated earlier today. And one list of authority volume 1.
List of authority volume 1 report. Yes, we joined the submissions also.
Written submission is second last.
He's also rejoined.
Yes,
Which was repeated earlier today.
and one list of authority volume 1.
List of authority volume 1, right? Yes, we joined the submissions also.
Written submission is second last.
Each of my lords has got that.
Yes.
Yes. Now let's. I borrow half an hour, so I'll be very pointed. So they have about 10-15 minutes left between them and us. Please see the larger issue for a minute, and then I'll read only some part of these two notes.
Volume 1, right?
The rejoinder one? Which one you want us to take first?
No, Lords may have all three open. I'm not going to follow this sequence. Each of my lords has got that. Yes. Now let's. I borrow half an hour, so I'll be very pointed. So they have about 10-15 minutes left between them and us. I'll take a different. Please see the larger issue for a minute, and then I'll read only some part of these two notes.
The rejoinder one? Which one you want us to take first?
No, Lords may have all three open. I'm not going to follow this sequence because I just go between rejoinder note, my first note, and CL1.
Yes.
These three things are 95-98% of my absolutist theory of signatory. I'll take a different sequence to make it shorter. Then your Lordship must throw out completely the doctrine. If not, then the best your lordships can. Perhaps my opening point is consider where the existing law. That was if your lordships were to go by this, what I call the absolutist theory of signatory or party in that sense, then your lordship must throw out already fleshed completely 12-15 the doctrines, which ring fence that doctrine. If not ready, then the best your lordships can and perhaps should do is to consider where the existing law needs trimming to the extent or safeguarding. That's point number 2. Tell your law trimming is a more appropriate word. This doctrine ring. Why will I say trimming? Because according to me, my law has already fleshed out 10, 12, 15 legal principles. I'm with them. I have no problem. Which ring fence that doctrine already. In these cases, they have not told from abuse. They are suggesting again and again. Now, certainly to the extent my learned friends on the opposite side tell your lordships that this doctrine ring-fenced by these 15 principles needs further tweaking in this particular sentence. They can't say that. I'm with them. I have no problem. Please throw out the group comment. But the problem with this case is they have not told us anything to say on their side. They are suggesting again and again that may either be by creating an apprehension without telling the lordships which of those safeguards needs tweaking so as to actually reduce the doctrine to vanishing point. Which reduces to vanishing so point without telling your lordships, because they know they can't say that. They can't tell your lordships. Normally, please throw out the group companies positive or negative wrongdoing only. Actually, that is a logical thing to say on their side. Only an example, I'll be reading in a minute. Realizing that may either be unrelatable or discretion is the better part of valor. That means that they say to keep the doctrine, even piercing the veil, but put so many unknown conditions which reduces to vanity, which another thing throw it out solely on wrongdoing. My lord, one of those points is must be positive or negative wrongdoing only. But that would mean, only an example, I'm reading in a minute. Either equate, take for example the repercussions of that point, piercing the veil. That means that absent even piercing the veil is not merely based on wrongdoing. It's a misrepresentation to your lordship to suggest that piercing the veil is based solely on wrongdoing. Particular safeguard, my lord pierces the veil in a wider set of contexts. Please ask them which of these safeguards is not enough, in what manner. But that would mean that your lordship will either equate the group doctrine only with piercing the veil. Let it be reduced to vanishing point by a circumvention. It's not the way it is put by the other side. It amounts to that. The doctrine is okay, but in some unstated manner. So, please ask them which particular safeguard, and the lordship is to be reminded of those 15 safeguards. Please ask them which of these safeguards is not enough, in what manner. That's a constructive exercise. I will join them in that. First, turn to my but absent that, please don't let it be reduced to vanishing point by a circumvention or a camouflage. That remember the doctrine is okay, but in some unstated manner, backdrop, kindly turn to the last. Don't apply it to a non-signatory or to a non-party, which means there is no doctrine at all. It's a kind of an appendix. Now, with that backdrop, please turn to 3 portions in a different sequence. What I've done here is first turn to my rejoinder note, the last page. I have put the. I'm following a little different sequence. It will be quicker. Test for the concept. But remember these 3 points, which I said in the opening. With that backdrop, kindly turn to the last page of my rejoinder submission. Now, just give me a few minutes. I'll not read a single case on this page. The very last page, it's a kind of an appendix. It's not a para. Does it have the title? Test for recognized non-signatory. Now, what I've done here is I've done the reverse, and I think you'll actually find it useful. I have put this non-signatory is the complete test for the concept, and then the case law under it. There is no place in this jurisprudence. It's already there, but I've done the reverse because now just give me a few minutes. I'll not read a single case on this page. One test is intention of parties, commonality of interest necessary to bind non-signatories. First of all, as my Ms. Arora also said, I said in the opening, this non-signatory is a complete red herring phrase. Yes, this phrase non-signatory actually has no place in this jurisprudence. I'll tell you why. Now, because non-signatory, of course, we are using if you are a signatory, the doctrine doesn't arise. Now come to this. It doesn't arise. Then you must have an all or nothing. The moment you are not a signatory, the doctrine doesn't arise. Just see. Full stop. The lordship throws out whatever the lordship wants to throw out. So, the whole doctrine is, yes, a non-signatory can be there to what extent?
Express party, implied party.
Implied. And I'm grateful to my so, non-signatory, of course, we are using the jurisprudence, so it's okay. You can go along. That's the concept also. Now come to this. Intention of parties, commonality of interest necessary to bind non-signatories. Volume 1. Now let's just see. These are chapter and verse specific paras where my lord has his 3 judges, 5 judges, or 2 judges laid it down this whole page. I'm saving time to specific paras to pinpoint it. And I'm grateful to my learned friends, Mr. Himanshi Vaidavaras, for having done that exercise. Under my supervision, it's useful to have it called out. Now see that. And I've got CL1. Altering, which is your lordship's volume 1, otherwise sometimes CL2. My lord has given reasons. Now, my lord has so many times your lordship has done it. The question your lordship should ask is, what is the imperative necessity of throwing out this whole page? Because if your lordship really were to apply the true test, then your lordship should throw out this page. Engaged in negotiation of performance. Reverse this page, overrule this page. Now see the next test. This answers both. Altering or piercing of corporate veil may be required. My lord has given reasons. My lord has had in 2, 3, and 5 years given reasons. Your lordship does look for the intent. Now, unless something compellingly wrong is shown, then all this should be overruled because your lordship goes by intent. But intent is both a subjective and objective. Engaged in negotiation of performance of the commercial contract. Subjective test where I tell your lordships. Well, actually, what happens is this answers both the shielding point and the wrongdoing point. Create a structure whereby, despite my full involvement, I will say your lordship does look for the intent. Let me give a nuanced answer to the point. Of course, your lordship goes by intent. Your lordship is the judge there. But intent is both a subjective and objective test.
That should reduce the subjective intent.
It's not a subjective test where I tell your lordships. That's my next sentence. I know I'm fully involved in this contract. The subjective intent, but I will create a structure whereby, despite my full involvement, I will say my intent is to shield myself from arbitration.
As one of the cases
that your lordship objective test kicks in. Your lordship is the judge.
subject, as one of the cases says, that it gives the subjective intent of the parties from objective fact.
That's my next sentence. Therefore, the subjective intent test alone, the lordship says, yes, is constitutive of great injustice. No, and then your lordship must overrule the doctrine. Family-run companies through complex structure is one. What your lordship has never done is no or yes are black and white. My lordship has operated in the zone of grey. Otherwise, why does your lordship your 15 principles will then be doing justice? Because your lordship knows case by case justice can't be done without these 15 principles. Otherwise, your lordship says yes, we accept it fully, or we don't accept it at all. No, your lordship says we accept it, but family-run companies through complex structure is one test. Logical application of the other. Yes, we accept it, but tight group structure with strong organizational financial links is another test. Yes, if your lordship that is the right way to do it with respect, because your lordship will then be doing justice without straightjacketing it in an exhaustive manner for unknown speculative situations in the future, which your lordship can never predict. With great respect, lordships can never predict. Does your lordship want that injustice either on a logical application of the other side's case, or my respectful submission has to be, the answer has to be no. Yes, if your lordships can be pointed out any major fallacy or error in this page 6 principles I've given, then your lordship can tweak it. Extreme and dispositive, conclusive. Has anybody told your lordship specifically in what language to tweak it? Then with great respect, I ask that question of myself. Not really. Because the intent either is to throw the baby out of the bathwater, or say it in a generalized way without telling your lordship which principle is wrong here. It is already. That subjective objective is very important for the Chief Justice also. And balance. If your lordship were to give extreme and dispositive, conclusive weight to subjective intent, my lord, then really your lordship is saying every non-signatory system is there. Just because the intent of the non-signatory is not to be bound. We will not. Then why have a signatory? Why have a doctrine at all? Injecting some objective intent. It is already that your lordship's objective intent kicks in and balances the subjective intent. But it has never been the absolute subjective intent. As I leave this page, my lord applies the mind that objectively the whole system is there. Just because he has ring-fenced or created a structure, we will not leave our adjudicatory job of injecting some objective intent. The lordship has to do justice. Lordship has case law, lordship has decision. That's the real structure. Why the constitutional bench? I'm not saying lordship can't do it. So, as I leave this page, many or all of these should be overruled. As I leave this page, I find 3 takeaways, if I may use the word, is one, would your lordships have any compelling need shown to your lordships by the other side to overrule this page? The second question number 1. This page is, the lordship has jurisprudence, the lordship has case law, the lordship has decisions. There must be something shown why the constitutional bench. I'm not saying lordships can't do it, but really many or all of these should be overruled. And certainly, because I find that the compelling need, if at all, is the opposite side, not this side, the decade of chloro. So, your lordship should overrule.
10 years after,
the second takeaway from this page is,
we haven't yet come across a critical mass of contradictory views.
I'm sorry, my apologies.
In the context of chloro control principle. It's perhaps a little too early. As you are saying, that there are
useful phrase. There are no adds rightly that to 10 years after. Chloro. The lordship is celebrating the decade of chloro.
Cases.
So, the lordship should overrule.
10 years after that this is just a thought. Excessively applied. We haven't yet come across a critical mass of contradictory views in the context of chloro control principle. It's perhaps a little too early. As you are saying, that there are no
possible for a constitution bench.
Another set of cases which had proved to the court that this doctrine is excessively applied or overarched or wide enough, so much so that the court should take a step back and control. We haven't yet arrived at that situation, is what you're saying.
I'm extremely grateful, and may I, with your lordship permission, adopt that phrase, critical mass. That is the critical phrase. Find it unpalatable. It is possible for a constitution bench, which finds a predisposition of a mass of cases this way, that is either equal or heavily weighted against the chloro doctrine. The consequence, it is possible. The lordship reaches a critical mass mass sometime in the future.
They have not brought forth.
Otherwise, really the Constitution bench is being asked to do an extraordinary thing. And again, it is left unstated by them because they know if they put it like that, God should find it unpalatable. I mean, there will be two. So it is not put like that. Most are in this one thing.
Fair, they have not put it at that level.
The interesting thing is, that's my problem. They have not put it, actually they mean that level. Exactly what that's my suspicion.
Right, you are saying that.
The consequence inevitable is that. That's the point.
But they have not brought forth, as Brother Nasir said, the critical mass of evidence.
Let's look at this critical mass phrase, very important phrase. Your Lordship has got most of the cases actually on this chart. I mean, there will be 2 or 3 missing, but most are in this one page. Well, the interesting thing is that the critical mass is leaning in favor of plural. So what is the Constitution being asked to do? It's asked to create a new status quo. Without showing that the existing status quo has run amok, has evidence that international commerce was being affected. Without demonstrating in any reasonable way that the existing status quo has run amok, these judgments have been controlled. They've been actually very calibrated. For example, your Lordship has some judgments. They've not gone overboard. I'll not name them in the old times, etc. I mean, one I can name as I argued with Balco, the private place of Hatia. The Lordship has evidence that international commerce was being affected. Section C. Just the whole UN crack on Section B. I formulated, but these judgments have been controlled. They've been actually very calibrated. Very careful, cautious. They've not gone overboard. This really
get the point.
This is what now should be a Lordship's. The second aspect is, and none are made out. Come to my first note here to the other side. Whether the Section C, but it's just stop for 30 seconds on Section B. I formulated the 2 issues. You must remember the origin. These are the only 2 issues. In my B.1, this is the first note. Whether you the opening note. I'll not read it, Lordship knows the original and rejoinder. This really should be a Lordship's broad guiding pole star, these 2 issues. And none are made out. Lower down that in favor of the other side. First note. Whether the acceptance, etc., of the group doctrine by several religions is not permissible within the 4 corners of 96. That's a clear, good guide. Same chart, but put in the point. And second is Dihor Sabha, put in the whether you should. So first is true and genuine original of the real intent of parties. But the broad guideline. Now because of Section C, category C, lower down that first note itself. First note, opening note. Suppose the Lordship were to find in a case that the real what are those 12 or 15 things? Suppose I read a sentence. Context by negotiation is the same chart, not but put in the point of submissions. Put in the form of submissions. It's not bound by arbitration. So first is true and genuine effectuation of the real intent of parties. My Lord says enough tools. But real intent where it becomes a form of avoidance, no. Then the objective test comes in. Second, suppose the Lordship were to find in a case that the real intent actually by performance, by context, by negotiation is not to be involved. Then the Lordship will say, no, there's no proof of this. It's not bound by arbitration. The Lordship will is an existing law. What is wrong with that law? Suppose the Lordship gives a finding of fact. My Lord says this case, actual case, not to punish an innocent party. I am fully involved in negotiation, plus I am fully involved in performance. Second, but because I am a foreigner, I have so designed related entities playing a predominant role, both at the negotiation stage at the inception and in the performance role. Now, suppose, both these tests, this is an answer also to the subjective objective, which my Lord's Chief Justice formulated. Suppose the Lordship gives a finding of fact in act, not this case, actual case, that I am fully involved in negotiation, plus I am fully involved in performance. Certainly the Whale Doctrine, even there. But because I am a foreigner, I have so designed it that I don't want to be caught in arbitration. Even they are doesn't matter. Sorry, it doesn't matter. But certainly the Lordship should be able to control that. Coincide with only the Whale Doctrine. Absence as a group doctrine would allow evasion and avoidance of legitimate collective responsibility. That's a consequence. I'll leave that. Hypothetical approach. I'll leave that. A very, very now, certainly the Whale Doctrine, even they have 11. That's C.5. Policy and a public policy. Even they are conceding. Not that some form or the other. But certainly I am not agreeing that it is coincide with only the Whale Doctrine. In a genuine case where a Lordship gets a fragmentation, why should the Lordship allow it? In effect, you are using it to stop. Rest Lordship is seen a very, very important concept is C11 approach in a whole set of jurisprudence. This is a judicial policy and a public policy. Not that any single swallow will make a summer. No single malus point is enough. But the totality your lordship will see. In a genuine case where a lordship gets a fragmentation malus, why should lordship allow it? Given C9, which is composite. In effect, you are using it to stop what? Legitimate arbitration. Anyway, this is just to remind my look at whether the lordship's pro-arbitration approach in a whole set of jurisprudence. In effect, C11 means you are thwarting arbitration because you are fragmenting it. C, in effect, no effective decrees passed are more important than they are given the weight of. Claiming through or under in the law commission is not being enough weight by them. I've given C9, which is composite and all that, saying non-signatories will not nullify this. Anyway, this is just to remind my lord, all of these principles are there. I'm not reading. There are about 12 or 14 answers. That has not been really. But there's a word here, and I go back to my INDI faithfully. C15 and C16 are more important than they are given the weight of. Claiming through or under the law commission is not being enough weight by the other side. If that is so malus, then merely saying non-signatories will not nullify this. I've given various reasons for C15 and C16. That has not been answered, that has not been really dealt with. That, according to me, I reiterate fully. The entirety of the law commission, the 21H argument, section 8, I'm saving time, I'm not reading it. That is an important consideration in the response. 72 of chloro in my CL1 provides for clear intent to bind signatory, and now I come malus to marriage. Not be restricted only to intention to marriage or appears for cooperative, political, tight group structure. Same point I made very quickly, but I'll finish with the second point made is party autonomy. First is who is a party must be in accord and comply with principles of law and contract. First, that's the point. I'll not read the point, but I'll read his response. Kindly come 72 of chloro in my CL1 provides for clear intent to bind signatory and non-signatory. Cannot be restricted only to intention to consider peers cooperative, political, tight group structure. Same point I made. Second point made is party autonomy. So the first point I really made, appreciate the I'm not fully reading it. What's the point? Second is party autonomy. It is so simple. What is party autonomy? Kindly come to my response. It is essential to understand the true intent by way of the conduct. It is submitted in party autonomy would negate the doctrine. This honorable court in ONGC in para 40 has laid down the test. Mutual intention, relationship of a non-signatory, commonality of subject matter, composite nature, performance of contract. What's the point of ring fencing with 5 safeguards? It is so simple. Privity is not factor. Party autonomy, then all this is useless. Less categories of privity not. Clearly I have a non-signatory, clearly I have no. What's the point of all the doctrines? On the contrary, all the doctrines is finding a way to effectuate the doctrine while protecting the end of contract. And that's the right approach. Third, privity of contract. This is written same answer 70 years ago. These are all traditional doctrines. Law is not advanced. If you go back to privity, because how many categories does a lordship have? The privity is not exercised. Does a lordship have less categories of privity not exercised? Because there is a book by Michael Akia, in fact, which I read in my student days, the beginning of the end of contractual intent may be held to be bound on a consensual theory. This is written almost 70 years ago. English people who are conservative found the beginning of the end of contractual intent. These are a lot of today told party autonomy and contractual intent is conclusive dispositive, which has adopted those authors, Gary Bourne, etc. have given these theories. There was more. Maybe one of the how the same cannot be sold based. In fact, case of non-signatory, this court is the doctrine of the cooperative non-signatory may be held to around on a consensual theory, found on agency, assignment, non-consensual basis, stop altering. The courts have added additional elements, common intention, negotiation. These are all juristic principles by eminent authors and a lot of judgments which has adopted those authors, Gary Bourne, etc. have given these first notes 350 and 360. In addition, it has been held. It's a repetition really of chloro with the para of para 39 ONGC. Without that para 4 is that. The court may lay down the parameters which permit play in the joints. The court will examine these exceptions. Now this is through or under is para 5 of the party. Through or under. Through or under relates to my first note C15 and C16. Just to cross references. My first note C15 and C16. In addition, it has been held in para 73 of chloro that a non-signatory could be subject to arbitration without their prior para exceptional cases. The court may lay down parameters which permit play in the joints. Some court will examine these exceptions as a structure of direct relationship of the party to the agreement, direct commonality, and agreement between the parties being a composite transaction. An intelligence doctrine is para. This Para 9 minutes about implies US and Germany, we're not spending time. Para 6-7. Your Lordship will come submission. Para 8 for the reasons. A. Doctrine, a point I've already made. Each case, compelling reason, entrenched doctrine. If your Lordship were to find, adopt this all or nothing, then there will be no grey area. Compelling reason not shown to your Lordship. GCD, an entrenched doctrine is para 8. Para 9 minutes about implied consent. The phrase is from your Lordship, section 7. The above submissions cannot be accepted for the reasons. A. Doctrine be applied in facts and such that each case cannot be a straitjacket formula and the parties. And if you Lordship were to find adopt this all or nothing, then there will be no grey area because you can't handle individual cases in future. From GCD is a reasonable and a natural extension of piercing the veil doctrine. Some or all already established legal tests regarding piercing would be applicable depending on individual facts. If your Lordship comes to that factual conclusion, then you have chosen a private forum is argument number 10. Intention doctrine. This. Parties have a right to choose the forum and the parties to the agreement, but circumstances arise where a non-signatory company can be roped into arbitration because the court found the existence, quote-unquote, from MTNL. A tight group structure with strong organizational and financial links so as to constitute a single economic unit or a single economic reality. If your Lordship comes to that factual conclusion in a case, why should the tyranny of an intention doctrine defeat this? Is my question to myself. Then 11. Ivan and for Mr. Advani, but I would beseech my lords to keep one thing in mind. Your lordship already has sufficient guidelines. Naturally, your lordships can tweak it in this way, that way, a little bit to make sure it's strengthened. But otherwise, there is nothing in this case in terms of either absolutist or completely. Otherwise, it would actually wreak havoc on what is now an established trend of law. That's very deep.
Dr. Singhi.
Ivan and for Mr. Advani, but I would beseech my lords to keep one thing in mind. Your lordship already has sufficient guidelines. Naturally, your lordships can tweak it in this way, that way, a little bit to make sure it's strengthened. But otherwise, there is nothing in this case in terms of either absolutist or completely. Otherwise, it would actually wreak havoc on what is now an established trend of law. That's very deep.
Dr. Singhi, amongst the multiple talents that you have, you also have the talent of deep reading because it closed. Deep reading.
I do not want to reveal a bar secret, but I can.
Even if I did, because I would not disclose. It's very valuable talent so long as it's kept hidden.
Because that's a talent by itself.
Because I can assure Lordship, I don't. And that to hear the subtext of what the Lordship says seems to be in my favor, but I don't know. I'm never presumptuous about adjudication.
You may not want to You may not want to reveal a bar secret, but I can tell you a secret which I picked up. I was sitting exactly where your junior is sitting, and where you are standing, Mr. Pali Nariman was leading me. That was a withdrawal of the prosecution of the Chief Minister's section, power under section 321 of the CRPC.
Oh, yes.
Had come up and had been referred to a constitutional bench to serve by Chief Justice Bhagwati. Authority was going to
Shivanand Paswan was.
Right, Shivanand.
I was on the opposite side. I was on the opposite side.
And, that was where Justice Bharuri
3-2. Justice Venkat Raman, 3-2.
That's right. They ultimately, the matter went 3-2 in the constitutional bench.
3-2.
So the judges were conversing. And I was briefing sitting by the senior Mr. Nariman. Something which was not left. And I thought that I'll use the time to tell him what next line of authority was going to be. So he turns to me and says, never speak when the judges are speaking. So I said, sorry. Then we left the court at 4 o'clock. He said,
but I'll just take about a minute and a half. 15 seconds for me. Respond to what Ms. Arora said.
Something which is not left me, learning lessons from the greats at the bar.
I shall pay more attention to this very wise advice.
We are now inventing how to read the minds of lawyers while sitting here.
I believe that.
Deeply obliged. Very deeply obliged.
Your Lordships know what happens when we are on this side.
Yes.
Plus, I'll just take about a minute and a half, 15 seconds for me to respond to what Ms. Arora said.
Yeah.
1 minute to respond. As far as the submission which Ms. Arora had made, there's just one aspect I want to point out. That while it is a section 9, the entire determination which your Lordships will see at paragraph 6, 7 and 12 of the judgment was only on the proof of companies doctrine. So as far as the issue is concerned, the issue is in fact the identical issue that your Lordships is hearing in 501. So it shouldn't be delinked in any form. That's the only one point. There's just one thing that fell from my Lord's Justice. As far as the submission which Ms. Arora has made, there's just one aspect I want to point out. Cases being brought before my while it is a section 9, the entire determination which your Lordships will see at paragraph 6, 7 and 12 of the judgment was only on the proof of companies doctrine. So as far as the issue is concerned, the issue is in fact the identical issue that your Lordships is hearing in 501. So it shouldn't be delinked in any form. That's the only one point we have. There's just one thing that fell from my Lord's Justice Narasimha, which is in relation to has the critical mass of cases been brought before my Lords to say there's some kind of abuse or not. Because I think there are two ways to look at this. But I can tell your Lordships that the first way, my Lords, is cases where which are the two countries we are akin, international, at least as far as adoption of the model law is concerned, and also localized theory. England and Singapore. And both those countries have rejected the doctrine. We have not. Awards take time to come. So, are you really consistent with two other countries which follow the same? Because my respectful submission is no, that's one part of it. And therefore, when your Lordships is considering it, I don't want to give you evidence at the bar, but I can tell your Lordships that there are at least 15 or 20 cases where I have been in international, domestic, where these issues crop up very, very much. Now, obviously, they're not there before my Lord because if a section 16 gets dismissed and jurisdiction is upheld, because awards take time to come, 34s are challenged, the issues may not be there. But there are a number of these issues, and therefore, when your Lordships is considering it, all I am requesting for is bringing about a level of certainty. Now, why would I not apply this if I was in Singapore and London? I wouldn't apply it there because if a group structure is brought, party takes a simpler route. It goes to the English Commercial Court or it goes to the Singapore International Commercial Court or it goes to the Singapore High Court and says, I don't need to go to arbitration. I have a great commercial remedy. I go to court, I get the injunction I want, I get a trial disposed of within 2 years, 3 years, and that's the end of the matter. Center, which should file an intervention application. We have a commercial and I got my 7.5 minutes on that side of the table. And that's really minutes.
Let's give 5 minutes to Mr. Advani.
I'm just for patient hearing. And I must just point out to my Lord one very interesting aspect. It's a very personal aspect.
Thank you, Mr.
The first time I appeared before a CB
Thank you, Dr. Singhvi.
was in 2012 in the Balco case.
Just want to present
When I appeared for the Singapore International Arbitration Center, which had filed an intervention application, and I got my 7.5 minutes on that side of the table, right towards the end. Because this is, in fact, from an arbitration perspective, the second time, I mean, I've appeared before other CVs, I mean, over that 10-12 year period. But from an arbitration perspective, this is the second time I've actually addressed a CB on
Thank
this.
you, Mr. Thank you.
And I'm deeply grateful for a very clear.
Thank you, Dr. Singhvi. Yes,
I just want to present a slightly different perspective. I'm not going through any case law, your lordship has heard it all, but all institutions all over the world, and I have been part of two of them, Singapore Arbitration Center and the Dubai Arbitration Center. The appointment of arbitrators is done by the institution. It is not a big judicial exercise. They are prima facie appointed. And then the arbitrators go into the issues, whether the group company doctrine or any other theories that are there, when non-signatories can be joined, and based on the facts, they make the decision. And now here also under our section 11 has been amended. It has not come into effect, and I'm told it's very close to coming into effect. The draft rules of the institutions have been published, and that process is on. Ultimately, it will be the institutions doing this role that your lordships are doing today. So, if your lordships leave the issues open as widely as possible, for every conceivable issue where the arbitrator thinks it's appropriate to join the non-signatory, let him take the decision. There may be 7 different theories. Why does your lordship confine them? After all, if your lordship resurrects the whole group concept of group companies has come from where? From Dow Chemicals. It's come from an award. It's not come from a court decision. And since now we're also going toward the appointment of arbitrators by the institutions appoint only prima facie. Arbitrators will come to finding the fact one way or the other and decide this issue. We've also done arbitration all over the globe. The arbitrators have considered it sensibly and joined or refused to join parties. This is happening consistently all over the globe. Why are we taking a restrictive view to this? Let's keep all the judgments are in place. They're well reasoned. Why do they need to be tinkered with? We have a stable body of judgments. Let the arbitrators follow them, whichever route they think is appropriate. They'll either agree they'll join the party or they won't join. Why do we do a narrowing exercise? Let the exercise be as broad as possible. And if an arbitrator goes too much out of line, the courts are there to correct him in a 34 application. So lordships will keep the judgments exactly as they are. The points raised in Justice Ramana's judgment were already answered by Justice Suryakant's judgment. There are several different tests. Why does your lordship want to narrow them? Let the arbitrator apply it depending on the facts of each case. And sooner or later, this is going to be an institutional exercise, not a court exercise. But let's leave it as wide as possible. Let's give the arbitrators ample room to take decisions. And if they go so wrong, the courts will correct them. Now, that was just a perspective I wanted to give your lordship.
Absolutely.
I'm obliged.
Thank you, Mr. Bani. Thank you very much. So
Grateful.
thank you.
Thank you.
Thank you.
I just had a small request to make.
Included judgment reserve. Yes.
I just had a small request to make, Manoj. We had also intervened IAF 58750 of 2023. May I have your lordship's leave? We'll put in written submissions. I want to prune it down in view of what has transpired.
Not more than 2 pages.
Absolutely, Manoj. We'll try and keep it short. Grateful, Manoj.
Thank you. Thank you. Thank you.
conduct when he's faced with emotion. Conduct when, and my lord, one of the things your lordships have been considering is the problem about whether the observations about of the earlier judgment of Nabam Rabia, whether they are to be read as a speaker denuded of power to act, be read as he is being subject to a code of conduct. One can is being subject to perhaps conduct. One can put it more on the manner of exercise of power, as I submitted last time. Put it more on the rather than absence of power, because there are 50 other functions which a speaker has to do. Rather than absence of power, because there are 50 other functions which a speaker has administrative jobs. He has to run the assembly. There may be other things going on. He has to run the assembly. Surely, one cannot suggest that the speaker must sit at home and sit it out till his. One cannot suggest that the speaker must sit at home. There is some check and balance within the system, and your lordships have in the statute compilation check and balance within the system. The Maharashtra Assembly rules, and I believe there are similar rules in other assemblies too. The Maharashtra Assembly rules, and I believe there are similar. Your lordships have in other assemblies too. Rule 11, your lordships have, which gives the time limit of 15 days. Which gives the time limit of 15 and my lord, days. My respectful submission is, it might be, my respectful submission is, it may not be really feasible to say, it may not be black and white in what circumstances the speaker should or should not act. Normally, a person who's under a significant challenge should not act. Normally, a person who's under a significant challenge. If my lord, a speaker, look at our, I mean, it's now academic, but the reason why we went to court is the speaker did not even give the period which you have to give for a reply under the rules. The speaker did not even give the period which you have to give for a reply under the rules. It could be that the numbers were such that the speaker may have lost, and most probably lost his, the numbers were such that the speaker may have lost, most probably lost his, because my lord, one thing I do want to restate, I said this the other day, restate. We know paragraph 3 about split has been deleted. We know one of the things which did prevail when your lordships upheld this law in one of the things which did prevail when as not being an anti-dissent but anti-defection law is that if there's a sizable number of breakaways, anti-defection law is that if there's then it is not a defection of breakaways. Then it is excess, because there is one has to balance the right to dissent. Then it is excess, because there is one has to balance the right to.
But Mr. Sarve, then what is the sizable number of?
That's not for your lordships.
But Mr. Sarve, then what is the sizable?
The law bringing in split by black door. No, I'm sorry. I'm not inviting the court to do that. I'm saying something very different, Marad. In fact, my respectful submission is your lordship has to take it as you find it. Different, Marad. In fact, there was a provision for a split which has now been deleted. There was a provision.
So therefore, the plain consequences that a split goes away.
No, I'm sorry, Manoj, I'm not saying to the contrary.
So whether it's a 1/3 or a 2/3 or
this is to be ignored today.
So whether it's a 1/3 or a
that's irrelevant.
Or
is to be if you are found to have crossed the line, if you are found to have it doesn't help you to say that the number of people who cross the line is more than 1/3. It doesn't help you to say that. But whether that law, whether Kyoto, because Mr. Sibal also said maybe someday Kyoto will have to be relooked. Maybe even on this Kyoto will have to be relooked. Because has this law crossed the line and become an anti-dissent law? Is something your lordship will consider if the law is challenged. Cross the line and become an anti-dissent law is something your lordship. Because one thing, my lord, which your lordships would consider. Yes, we know there is a problem about political morality, but that problem is on both sides of the fence. Yes, we know there is a problem. It cannot be morality, but that problem. Once you're in, you lock the barn doors. It cannot be to say that a person becomes chief minister if his entire legislative party is rebelling against you. That a person becomes chief. You must wait till he goes to the election commission, then they get the party split at the election commission level. And then what happens? I go to the election commission and say, we are the real party. You come and have all your legislative members disqualified because no split now. You come and have all your. So you come to the speaker and say, all my entire party is rebelled, throw everybody out. I'm the sole person, you can't remove me from say, all chief minister. Entire party is rebelled. This is surely not what the law was meant to be. Remove me from chief minister. So all I'm saying is, yes, we know there is a problem. So, but all and the legislature has tried to address it by bringing in the 10th schedule to the extent it has. And the legislature has tried to address it by bringing in the 10th schedule. But this overstatement saying, because this is so, you must unscramble everything, you must transfer everything to the Supreme Court, saying a resigned chief minister must be asked by a mandamus to come back and take office, a resigned chief minister or his except of his resignation must be set aside. God knows what sort of release have been asked. Except of his resignation must be set aside. So, my respectful submission is, and even as far as the governor is concerned, the solicitor is addressing your lordship. But since one of the issues does arise, is challenged to the governor's order. But one thing which Bomai has laid down and laid down very clearly, the governor's order. One thing which Bomai is that floor tests are not to be in Raj Bhavan, floor tests are to be in the assembly. Is that floor tests are not to be in Raj Bhavan, floor tests are to be in the head counting is not to be done in Raj Bhavans, because that is the root of a major evil in Raj Bhavans. Because that is the root of a major whenever evil. There is a question mark on the ability of the chief minister to command confidence of the House, on the ability of the chief minister, the governor must call for a vote of confidence. The governor must call for a vote of confidence. The governor must not entertain people in Raj Bhavan and do head counting. The governor must that's the law your lordships have laid down to prevent politics from entering Raj Bhavan, if at all that is possible. To prevent politics from entering Raj Bhavan, if at all that is possible. When the governor calls for a vote of confidence, why should a chief minister continue in office even one day if he doesn't command the numbers? Why should a chief minister continue in office even one day? So yes, there is a problem of horse trading. But you are also leading a party. There is a problem of horse trading. If there is a problem within your party, the problem is not only to be resolved in courts. If there is a problem within your party, the problem is not only. So, but my respectful submission is getting into this thicket. Is inviting your lordships to depart from established constitutional principles which are judicially manageable. To depart from established constitutional. We have judicially manageable standards. Your lordships have said floor tests are the test. Manageable standards. Your lordships have said let democracy play out in the floor of the House. That's a lodestar of this law. Democracy play out in the floor of the House. The governor did nothing wrong in calling by floor test. This law. The governor did nothing wrong in calling by for a floor test.
Yes, Counsel.
Yes, ma'am. So, my lord, my.
Yes, Counsel.
Yes, ma'am. So, my lord, my.
Yes, Counsel. Yes.
Yes. So, my lord, my respectful submission is on the three steps. Yes. As far as the Navam Rabia judgment is concerned, as far as the first of all, that question doesn't arise, and it's not a matter which is free. First of all, from difficulty doesn't arise. But if your lordships do a matter which is free from difficulty, are persuaded to get into, my lord, relooking that judgment. Are persuaded to get into, my lord, relooking that judgment, then there has to be some discipline. There has to be some discipline. And that discipline can be brought in by a doctrine which we understand. And that's abuse of power. Brought in by a doctrine which we understand. And that's abuse of power. So, my lord, it's not absence of power, it's the manner of its exercise. And if in the facts of a case, you find that there is abuse of power, a speaker has jumped the gun and done something which he shouldn't have, the courts are there to remedy. That is the submission as far as Navam Review is concerned. Now, my lord, one other question which had come up, which I mentioned and your lordships are also saying. Now, my lord, can a mandamus issue, which I mentioned and your lordships to the governor to decide? Can a mandamus issue? My lord, that actually stands answered to decide. Because although it had been referred to 5 judges, a later judgment answers it based on the observations in Rana. A later judgment answers it, my lord, based on the observations. But on first principles also, my lord, there should be no difficulty. But on first principles, if your lordship sees the Quixote judgment on this, if your lordship sees the problem judgment on this, which is the problem sort of, which is the genesis of this submission is paragraph 54 of Quixote. It's in the compilation. Genesis of this submission is paragraph PDF page 111. It's in the compilation. The judgment's compilation. PDF page 111. The judgment's compilation. And the limitation on judicial review comes out of paragraph 7. The limitation on judicial review comes out of paragraph 7. And the question really is, and in one sense, a mundane question. What is the meaning of the phrase quia timet action or an interlocutory intervention? The phrase which your lordship have said is not permissible. Or an interlocutory intervention. Para 54 said is not permissible.
54.
Para 54, my lord.
So second compilation or third?
Second.
Second.
Judgment 2. Yeah, judgment 2. Second. PDF page 111. Oh, that's at least the page which I have. Judgment 2. PDF page 111. Oh, that's at least the page which I have.
Volume 1.
Volume 1.
Guru. Volume 1. Serial number 2 is Guru Gobind Bas. Guru. Quixote. Volume 1. Yeah, it's serial number 6. Guru Gobind Bas.
It is compilation volume 1.
Quixote. Yeah, it's serial number 6.
PDF. It is compilation volume PDF 1. Is page 111. Para 54. Is page 111. Para 54. And this is, my lord, discussing paragraph 7. And this is, my lord, discussing paragraph 7. Para 55, my lord, cites, in fact, the well-known rule in Mask Company that this is to be strictly construed. In fact, the well-known rule in Mask Company that this is to be strictly construed. And once your lordship has held and that the speaker is a quasi-judicial tribunal, then, my lord, this has to apply in that sense. If your lordship sees para 62, in that sense. In the present case, though the amendment does not bring directly any change in the language of 136, 226 and 227. However, in effect, para 7 curtails the operation of the articles and matters falling in 10 schedule. There is a change in so and so within the meaning of clause B of 368. Para 7 therefore attracts the passage having regard to the introduction of so and so the 10 schedule in effect bring about a change in 136. So the 10 schedule in effect bring about a change. My lord, it is in this context, so that your lordship said it is in this context you cannot have a quia timet that your lordship in para 54. You cannot have a quia timet. Now today, my lord, law has moved far ahead, including, my lord, the proposition that even by constitutional amendment you cannot water down to 26. Later cases. By constitutional amendment you cannot water down. But, my lord, I don't see this as a problem on the issue which your lordship is considering. But, my lord, I don't see this as a problem on the issue which your later judgment, where Justice Nariman has gone into the definitions. Where Justice Nariman has gone into the 3-judge bench, my lord, 2020 SCC online, a 3-judge SC page 55. SCC in this very bundle, your lordship will find it at page 1324. In this very bundle, your lordship will find it at page 1324. It's 3024.
What's the cause title, Mr. Salve?
It is Kesham Meghchandra Singh
What's the
and
cause
Speaker
title,
of
Mr.
Manipur.
Salve?
It is Kesham Meghchandra Singh
Bookmark
and
32.
Speaker of Manipur.
Bookmark 32.
Kesham.
There are two, 31 and 32 both.
I think this is 32. 31 was the first one.
Right, both.
I think this is 32. 31 was the first 31.
Right. Yeah.
It's a bench of three learned judges, man.
Yeah.
It's a bench of three learned judges, man.
Yes, we do have.
What your lordships did in this case, because here this question came up, your lordship said we have referred it in this case, but without noticing that the matter already stands answered by Rana. Noticing that the matter already stands the relevant passage straight away, if I may cut to the chase, but if your lordships come straight to the relevant passage page 1332 PDF, para 20, page citing from Rana. In fact, Manoj, if your lordship turns to page 1331, citing from Rana. In fact, Manoj, if your lordship turns to page 1331, from para 15, your lordship starts citing Rana's judgment. From para 15, your lordship starts citing Rana's judgment. And at the extract in para 17 of this judgment, the extract which says after referring to the court's decision in Kyoto and Ravi Nayak in para 22 the court held decision in Kyoto and Ravi Nayak in para 22 the court held. Then in para your lordship's extract para 22, suffice it to say decision of the speaker on 6 September was not immune from challenge before the High Court 227. The court then went on to hold then para 25 on the scheme of 102 and 191 of the 10th schedule. The determination of the question of split or merger cannot be divorced from the motion before the speaker seeking the disqualification of members, therefore not possible to accede that under 10th schedule. Speaker as an independent part to decide that there has been a split or merger as contemplated by para 3 and 4. The power to recognize a separate group in Parliament may rest with the Speaker on the basis of rules of business. That is different from saying that the power is available under the 10th schedule to the Constitution, independent of a claim being determined, or a number of members had incurred disqualification. To that extent, the decision of the Speaker on the hand cannot be considered to be an order in terms of the 10th schedule. The Speaker has failed to decide the question he was called upon to decide by postponing a decision thereon. This is the starting point of the proposition. Therefore, there is a failure to do your duty. It's a tribunal which fails to do the duty. Then, my lord, in the next para, about 6 or 7 lines, my lord, there is a line which is underscored and it says, the failure on the part of the Speaker to decide the application seeking a disqualification cannot be said to be merely in the realm of procedure. It goes against the very constitutional scheme of adjudication contemplated by the 10th schedule read in the context of 102 and 191 of the Constitution. It also goes against the rules framed in that behalf and the procedure he was expected to follow. And then, my lord, your lordships, if your lordships turn to page 1332, your lordships, the extracts in para 20 of your lordship's judgment, your lordship start by saying the court then adverted to the scope of judicial review being limited as was decided in Kyoto as follows. And then, my lord, after those passages in Kyoto as follows. And then, my lord, after those passages, para 40 is set out, my lord, at the foot of that page, which says, coming now to the foot of case in hand, it is clear Speaker in the original order left the question of disqualification undecided. Thereby, he failed to exercise the jurisdiction conferred on him in para 6. Such a failure to exercise jurisdiction cannot held to be covered by the shield of para 6 of the schedule. He has also proceeded to accept that a split being merely on a claim, he has entered no finding of the split in the original part he was prima facie proved or not. The action was apparently based on an understanding of his ratio of Nayak. He misunderstood the ratio. Now that we have approved the reasoning and approach of Judge Singh, and the ratio is clear, it has to be held. Speaker has committed an error which goes to the root of the matter. So fundamentally, even a limited judicial review has to be interfered with. Therefore, no hesitation in agreeing. In view of our conclusions above, nothing turns on the arguments urged on what were described as significant facts on the alleged belatedness of the amendment to the writ. It is indisputable order was originally subjected to the writ. Speaker specifically refrained from deciding the petition. On our reasoning, clearly there was an error which attracted the jurisdiction of the High Court in exercising the power power of judicial review. So your lordships have said failure to decide itself in exercise of the power of judicial is a jurisdictional error which can be corrected under 26, reviewed under 226. This question already stands answered. And then in para 24, I want to take your lordship's time reading it beyond that one definition in para 24, a quare timid is because beyond that one definition you fear or you apprehend. A quare timid is because you now here there is no fear or apprehension, my lord. If a speaker is not deciding, now here there is no fear or apprehension. There is no fear or apprehension. It's an established fact. Something. There is no fear or apprehension. It's an then, my lord, para 29 and 32, and then I'm done with this. Para 29 is at the page 1334. Para 29 is at the reading of the decision shows that what was meant to be outside the pale of judicial review in para 110 of Quixote are quatimate actions in the sense of injunctions to prevent the speaker from making a decision on the ground of imminent apprehended danger, which will be irreparable in the sense that if the speaker proceeds to decide that a person be disqualified, he incurs the penalty of forfeiting his membership of the House for a long period. 110 and 111 of Quixote do not therefore in any manner interdict judicial review in aid of the speaker arriving at a prompt decision as to the disqualification of the provisions of the 10th schedule. Indeed, the speaker in acting as a tribunal of the 10th schedule is bound to decide within a reasonable period. What is reasonable will depend on the facts of each case, but absent exceptional circumstances for which there is good reason, a period of 3 months from the date on which the petition is filed is the outer limit within which the disqualification filed before the speaker must be decided if the constitutional objective of disqualifying persons who infracted the 10th schedule is to be adhered to. This period has been fixed keeping in mind that the ordinary life of the Lok Sabha and Legislative Assembly of the states is so and so forth. And then, my lord, finally, the foot of page 1335, para 32. 13. But after having held all this, please see what your lordships do. It is not possible to exceed Mr. Civil submission that the court issue a writ of quo warrant for quashing the appointment of the respondent as a minister of a cabinet led by the BJP government. Mrs. Diwan is right in stating that a disqualification under the 10th schedule to being an MLA and consequently minister must first be decided by the exclusive authority in this behalf, namely the Speaker of the Manipur Legislative Assembly. It will also not be possible to accede to the argument that the disqualification petition be decided by this court in these appeals, given the inaction of the Speaker. It cannot be said that in the facts of the present case are similar to the Rana case. In the present case, the Legislative Assembly comes to an end in March 22, unlike the case, unlike in Rana, where the court, but for the court deciding the disqualification, no relief could have been given to the petitioner, etc. The only relief that can be given is that the speaker be directed to decide the disqualification, pending before him within a period of 4 weeks from the date on which the judgment is intimated to him. Within a period of 4 weeks from the date on which the judgment. But I commend this judgment for your lordship's acceptance. It's sound on principle, it's sound on logic. It's sound on principle, it's sound on logic. So, my lord, to close, therefore. So, my lord, I start by saying, my lord, your lordship is being invited to embark on a journey. Your lordship is being invited, which is entirely political in nature. My lord, it's a journey without a destination. And that journey is to speculate on what would have happened. That journey is to speculate had a trust would actually happen. Had a trust would actually happen. Even in, because your lordships have never come to the conclusion, and I dare say your lordships never will, because your lordships that the pendency of a challenge somebody is continuing in the house, that the renders that person somebody is continuing in the house, renders that legally disqualified until he's requalified by dismissal of a disqualification. Disqualified until till your disqualification is decided, you are entitled to participate and vote. Yes, the system is not powerless. The courts are not powerless. If you find that trust vote, in fact, was vitiated by the participation of a large number of people who 3 days later were disqualified. And what has happened is an abuse of the power and abuse of the constitutional provisions. The courts can always intervene. Abuse of the power and abuse of the constitutional provisions. The courts can always intervene. Now, my lord, today, apart from the figures which we have given to your lordship, the admitted position is there were 16 petitions on which notice was issued. And the gap was 58. There were 16 petitions. Now, what would have happened? Forget this 58. This is also a coalition government. God knows what would have happened. Forget when the trust vote, if it had at all taken place. So, my lord, to invite your lordships to assume like a legal fiction. So, my lord, if that trust vote had happened and if these 20 had been left out, or these 32 had been left out, and then the balance would have had a change of heart, or something else would have happened, and then all these votes would have gone, and our coalition partners would have supported, and so and so would have won the trust vote. And our coalition is a journey which your lordships would not embark on. Now, if I'm right there, then nothing survives in the first part of this case. I'm right there. The second part of this case is swearing in of Eknath Shinde. Now, what did the governor do wrong? The second part of this case is a chief minister has resigned. He has to accept his resignation. What did the governor do wrong? Another person comes and says, I represent a party on which elections have, I represent a majority in the House. He goes. Elections have, he has not won the majority. I represent a majority in the House. Now, if somebody says that he has won the majority by abuse of power because disqualification, somebody says that those are matters yet to be resolved. How many numbers, how many are pending, what has happened to the disqualification? How many numbers, how many are pending, what has happened? I do remember, my lord, before the former Chief Justice, because the tide had turned, as they say, before the former Chief Justice, and there were cross-disqualification petitions against those who voted against the present incumbent. And there were cross-disqualification petitions against those who voted against. And they did also want the Speaker to decide those disqualifications. And they did also. So virtually there was, I remember on one of the hearings, the idea was don't aggravate things. There was things like that's why things have not been decided. The idea was don't aggravate things. Your lordship will direct in whatever reasonable time the Speaker will decide now all pending disqualifications. If somebody is dissatisfied, you have your remedies under Article 226 if the Speaker gets it wrong. If somebody is dissatisfied, that's all that remains in this case now. Is my respectful submission. That's all that remains in this one broad submission. The second is, my lord, there is no occasion because this one broad submission. The second is, my lord, there is no occasion because this.
Yes, Commissioner. Yes, Mr.
The second, my lord, I was submitting, even this Navam Rabia, my lord, is a very thorny issue. The second, but if your lordships do get into it, then I have made my submission. Thirdly, my lord, there is no impediment in issuing any direction to the Speaker to decide. And that's really where this case must now end. Your lordship will direct the Speaker within a defined period of time. My lord, dispose of all pending cases, and the matter must end there. That, my lord, is the submission, unless there's anything else I can assist your lordship with.
Thank you, Mr. Savay. Thank you.
Submission, unless there's anything else I can assist your lordship with.
Thank you, Mr.
Yes,
Savay. Thank you.
As your lordships were kind enough on the last day to permit me to sum up, because I had submitted my arguments, and I had also handed over to your lordships three things, my lords. One was the judgments, which we had distinguished. The other was the timeline, my lords, with the crucial events as they unfolded. And the third was propositions and case law, which I have handed over. And then I read out on the last day the crucial relevant paragraphs. Let me now just sum up some of the crucial events, because there's no point in my again getting into those timelines which your lordships have read and reread again and again. And we both will have our side to say on the timelines, my lords. Again and again. And we both will have our side to say on the timelines, my lords. Firstly, it has been right through our contention that this is neither a case of merger or a case of split. Merger or a case of split. Our case right through has been that a rival faction within the Shiv Sena is actually the Shiv Sena and is entitled to be recognized as the recognized political party under the symbols order para 15. As the recognized political party, which today has been accepted by the competent constitutional body, which is the Election Commission, and the matter is pending accepted by the competent constitutional body. Now, till 2nd of July 2022, the entire allegation was a para 218 10th schedule allegation that you have voluntarily given up the membership of the party. And why have you voluntarily given up the membership of the party? Because you failed to attend a meeting at a 2-day notice. Because you failed to attend a meeting. You failed to attend a meeting 2-day for the same evening. And the other where we never got a notice. For the same evening. And then the speaker, contrary to the rules, gives us 2 days instead of what is provided for. And it is at that stage that we approach this honorable court saying, A, violation of principles of natural justice, B, threat to our life in the state concerned, and 3, relying on Nabam Rebia to say that constitutional propriety requires that the speaker should first decide his own removal before deciding disqualification. So, my lord, still second, it's only a 2-1A case. And our respectful submission is, my lords, that internal dissent is the essence of democracy. And in repeated judgments your lordships have held that merely because within a party people are aggrieved by what is happening, question the leader, question the chief minister, even from the same party, is not a 2-1A case at all. And that is exactly what your lordships held in Balachandra versus Yadurappa to say that even where from within the party, the chief minister of the same party was questioned as continuing, it was held that this was not a 2-1A case at all. It was held that this was not a 2-1A case. So I don't have to rely on any defense at all of para 3 in any case which doesn't exist or para 4 at all of para 3 in any case which doesn't exist. Because I am saying that as far as I'm concerned, this is the party and I've been recognized today as the rival faction within the party. And definitely questioning and passing a resolution on the 21st which categorically said that there is overwhelming resentment with the fact that we are continuing in a coalition or were continuing in a coalition at that time with a party which has been politically and ideologically opposed to us for decades is causing great amount of resentment amongst the cadres and the party workers. So that is the resolution which reached the governor. Now, at this stage, my lords, so 2-1A, our respectful submission is this is not a case at all of a 2-1A case. In any case, my lords, whether it is a 2-1A case or a 2-1B case, who will decide that? The argument being raised before your lordship says these are per se cases. Because we say so, it is per se case, nothing else is required, and your lordship should bypass the entire constitutional machinery of coordinate constitutional authorities and decide it yourself. Without the speaker having decided the issue, because today we feel the speaker who ought to have been there is today not the only person. He's still the deputy speaker. There's a speaker in place who will be biased. So you decide the whole thing. This is the legal argument being made before your lordship. Contrary to every judgment on the point, including Quixote, that your lordships will not interfere till a final decision comes from the speaker on the point. Now, my lords, as far as the second part is concerned, which is 2-1B, which really commences on second, because then we are looking at two rival whips being issued. And our whip, as I had said, by an overwhelming majority of the legislature party had been appointed on 21st of June itself. They on the same date reiterated their faith in their earlier continuing whip. Now, the fundamental mistake in this argument is As if now what is happening is only in the legislature party and not in the political party. As if what is happening is only in the and our argument on that, my lords, repeatedly has been that these are co-joined, and our argument integrally connected, repeatedly has been organically connected, co-joined, and each influences the other. Organically connected, and each and that is why, my lords, I had read out to my lords on the last day. That is why, my lords, even para 4 of Schedule 10 on the last day, which categorically provided that a deeming fiction that for a merger of a political party, if 2/3 of the legislature party merges, a merger of a political party, if 2/3 of the legislature that is taken as a merger of the political party, as an indicator that you can't segregate the two. Because this whole argument is based is that it's only the political party, it's only the legislature party, not the political party. We also draw strength on what we are saying, my lords. We also draw strength on what we are saying, my lords. The symbols order, which itself provides from that for the continued recognition and existence of a political party, that for the continued recognition, the number of votes polled, political party, the number of MLAs and MPs, the number of votes which form the pool, are all part of the continuing existence and recognition of a political party. Are all part of the continuing existence and recognition of a political party. We also draw sustenance for our argument from Sadiq Ali's paragraph that I had read out to your lordships on the last date to say that percentage of votes, number of MPs relying on the symbol orders is an important integral indicator for a continuance of a political party and is to be taken into account when the EC decides the matter. And is to be taken into account when the EC decides the matter. So, my lords, to say that you just represented the legislature party and not the political party, that is a complete fallacy and misreading of the law. In fact, because this has been no one's case ever. In fact, our resolution consciously reflected the dissent within the party. The resolution did not say that it is just the legislature party. It talked about the political workers, the political party in question. It talked about the political workers, the political party in question. Now, my lords, as a practice there, I had also respectfully shown to my lords on the last date the Maharashtra Legislative Assembly rules. That at the end of the day, who is the speaker in touch with? At the end of the day, who is the speaker? The speaker is necessarily reliant, my lords, on the leader of the legislature party when it comes to recognizing a whip. Because under the rules, a member is elected as the leader of the legislature party. Because under the legislature party's leader is the one who is in touch with the speaker. The leader of the legislature party indicates to the speaker the various designations and posts held by the people. The leader of the legislature party also indicates to the speaker under Rule 3 subclause 4 any change which occurs. So today to say that the speaker in exercise of his power under para 2(1)(b) of the 10th schedule will embark on an inquiry into the issues of the political party and will not confine himself what to the whip or the leader of the party says is wrong. Because A, he cannot do it, he doesn't have the wherewithal. A political party is a much larger amalgam of taluka leaders, of district workers, of political workers, of parties. It's the ECI, which is the constituted constitutional authority, which goes into it and has exercised its jurisdiction, was at that time wanting to exercise its jurisdiction when your lordships were asked to stay that. And your lordships refused that stay, saying that that order must come from them. So the speaker does not embark on that inquiry at all. Now, even when para 3 existed, my lords, and I'm purposely now not getting into judgments again, even when para 3 existed, my lords, in Rana, your lordship said two significant things, my lords. In Rana, that the speaker will not embark on an independent inquiry as to a split in a political party. He holds the issue of disqualification. And as far as the issue of disqualification is concerned, It's a prima facie view that the Speaker will take. Because what is being asked today is that the Speaker will usurp a power that the Speaker does not possess and will get into the politics of the political party. Of course, the first presumption being that they are two independent and thus an inquiry must be carried out there. Now, my lords, the practice of the legislature party of the Shiv Sena right through, my lords, has been, and those two letters have already been shown to my lords, also handed over. One is part of the report, the other was handed over. Where it is always the legislature party or the leader of the legislature party which writes to the Speaker to say who is the whip or the leader of the party. There is no doubt that an overwhelming MLA is the majority appointed, Mr. Gogavle is the whip. There is no doubt that an overwhelming and that the earlier whip was removed. There is no doubt about it. Now today we have a situation even from 2nd of July. If it's a 2-1 case, we have two rival whips issuing two rival directions, presuming they are right and there was a rival. So there are two rival whips as per them. Now who will decide this? Again, the same argument of 218. Your lordships are being told that per se because we feel they have incurred disqualification, your lordships are not required to send it to anyone and please decide it yourself. Your lordships are not required to send it to anyone. And that is a common thread that I keep coming back to because your lordships are being asked, first your lordships are asked to bypass the election commission, which your lordships refuse. Now your lordships are being asked to bypass the speaker, which your lordships have to consider. And the third issue is of the governor, which I'll touch upon separately, my lord. And the third issue is coordinate constitutional authority separately, my lord. Vested with independent specific powers and areas of concern and interference which they have to deal with. And the governor deals with, does the chief minister and the government enjoy a majority? Is there political accountability? Does he enjoy the majority on the floor of the House? Is there political accountability? Does he enjoy the majority on the floor of the House? As far
determination by the Speaker. So the defense that you would take as against, the defense case of a split as against would be that there is actually a realignment to the political party and that you are the political party. Realignment to those defenses are all right, but we have to political party formulate the principle with respect to the decision that the Speaker is going to take at this stage. With respect to the, as I was indicating earlier, it may be a jurisdictional fact. Here, the distinction between a jurisdictional fact and the case that you set up, that it is actually a case where you control the political party, is actually a case where it's very thin. Control the political party. It's very easy for a speaker at one stage to say prima facie I think that it is there, or very easily he can say prima facie I don't think it's not a case. So to formulate that, I don't think that principle that speaker will take a prima facie view and come to a conclusion that it is not a case of a split, but it is a case where you have set up the control over the political party. What are the contours of that? That's one aspect. Another aspect of it is that this being a jurisdictional fact, because if he comes to the conclusion prima facie that it is not a case of a split, but it is a case where you have the control of the political party, you go out of the 10th schedule. So there is severely contested by the other side. So this goes to, there is severely contested judicial review on this very point. This goes to invariably. In reality, judicial review on this very point. So the Speaker has taken a prima facie view and adjourned the matter till determination by the Election Commission is what the order would be. So he says this can't be done, and according to it, the entire thing will revolve around numbers or the material that is there before the Speaker. Take the prima facie view or the material that is there before the Speaker. So it's a very slippery ground in that sense of now expecting the Speaker to take a prima facie view and the kind of a material that is available for him to do it. And what kind of prima facie case? And I accept that there are signatures as in the case of about 34 MLAs. And aspects such as how much of the political party has vouchsafed for one group or not. How much would be available at that stage? So as a principle, I would take it that your submission is that he would only take a prima facie view and refrain from proceeding with 10 schedule, expecting that the election commission will determine the matter. And after the election commission says that it is not a case where the other group has control, the matter comes back to the speaker and he will determine the case. That's the way you are
just to add to it, my lords, because a constitutional bench of this court in Rana has taken a view that you will not embark on an independent inquiry, de-horse disqualification and a prima facie view. And prima facie view on split, yes. And I tell you, Lordships, why? The speaker cannot get into something. The Election Commission of India has the machinery to determine that. But the other problem which also arises in this matter, your Lordships are right. There could be a problem, the peculiarities of a case. The problem arises also out of saying two distinct entities, the legislature and the political party. We are undermining the importance of overwhelming members of a legislature party, their resolutions passed, people supporting them, a competent body deciding on the issue. Because that is the only argument being made, that the speaker today should have gotten into it and should have not gone only by what the legislature party said. But that is a presumption that it's only the legislature party. But that presumption in law is wrong, because it is never alone a legislature party. They're both integrally connected, organically connected, co-joined. You can't presume when you say that it's just one and not the other. And that is why from the symbol share order, dying to Sadhikari everywhere, the word used is existence, recognition, continuance of political party. You fall back also amongst other grounds. Also on the percentage of votes, the MLAs, the MPs, and an indicator of it. And that's why I said, Manoj, these are all indicators in furtherance of what we are arguing, including para 410 schedule. Now, my lords, that whole deeming fiction, why is it there then? Now, my lords, and in any case, my lords, why is it there? To go back to what your lordships asked me, today the question is, will your lordships in a case like this get into and say that we'll decide it? Because they say it's a per se case. So every second party will come to court and say it's a per se case as per us. And you don't need to go anywhere else. No other constitutional authority needs to get into it. And your lordship should act as the court of first instance and decide all these issues. So you are taking away and depriving every other competent coordinate constitutional authority of their jurisdiction and are being asked to act as the court of first instance on all these matters. And Rana, my lords, as I had submitted, was a completely different case. In fact, Justice Nariman in the judgment which Mr. Salve also just read out, also deals with this issue, saying that for 4 years something was pending in the High Court. And then it came there. And then it was remanded back. It was being asked to be remanded back by the High Court. At that stage, the Supreme Court said the Assembly's term is coming to an end. So lordships were said that it's been done. But when has it been done? In what circumstances has been done? Is the law of the land that all other authorities will be deprived of their jurisdictions? Because in the peculiar facts of Rana, it was said that court in a particular case could decide it in the manner it did. It can't be. Then, my lords, as I had respectfully submitted, it can't be. Then, my lords, the two letters I had pointed out to my lords, which clearly demonstrates a practice. Now, today to turn around and say, so when you issued the letters, it was fine. Now, today to turn around and at that stage, the practice was fine. And necessarily, my lords, from the rules, as I said, that's the only way to do it. If a member or the leader of the legislature party has to be a member of the House, the rules say he will communicate. The rule says he will point out changes, he will point out designations. He will communicate. The rule says disobedience of the whip, he will point out under Rule 3.5. Not those rules, I'm not rereading, my lords. I've taken my lords through each of those rules. Until unless your lordship so directs me, I'll read those rules. Is provided therein. So where will the speaker today embark on this independent inquiry on disobedience of the whip, etc.? It has to be within the contours of what the rules provide and the Constitution provides. Will he go and call members from everywhere, political party, and then the argument made to your lordships was that at that stage only the leader of the political party should be in direct touch with. Can't be. We have to go by what the Constitution and the practicality says. If there are overwhelming majority today saying that we don't have a faith in the leader, let's test a proposition. Suppose an overwhelming members say we don't have the faith in the leader, but we want to be within the political party. Suppose an overwhelming members say. So to say speaker will get into an area where a constitution bench says yes, you will take a prima facie. Speaker will get into an area where a constitution bench. Now those contours of how the speaker exercises jurisdiction will first be left to the speaker to exercise it. Because judicial review is always available to your lordships of a decision by the speaker. What contours, what standards, what principles the speaker follows. After all, in Quixote, that's why your lordship said no quo timid, no interim injunctions. Let an order come, then we'll examine it. No interim injunctions. Let an order come. And today your lordships are told that in the legislature party, this was only the legislature party, and they've hijacked the political party. And because the deputy speaker no longer, it's another speaker who's deciding, thus your lordships must decide it. That's the argument being made today. And it's a per se case. So all authorities, all principles be ignored because we say it's a per se case, your lordships must decide. All authorities, and because Rana had decided. Ignored because we say it's a per se case, your lordships. Then, my lords, and because Rana had decided. Then, my lords, another question that your lordships had earlier also posed to us, and today also the lordships posed to Mr. Salve also was earlier also posed to us on also relating back and whether applying prospectively. On relating back and whether applying prospectively. But Rana, as I had respectfully read out, was a decision where the Supreme Court exercised its jurisdiction to say that on the day disqualification was incurred, that on the split had not disqualification was incurred. The speaker went ahead with the split and not decided the disqualification. Went ahead with the split. This court said that when it said it relates back ex post facto, the facts as far as disqualification are concerned will be seen on the day when they incur disqualification, not by subsequent split in the party that may have happened. That's an event only inconsequential for deciding disqualification. That may have ex post facto was used in that context. Now that ex post facto is being used to argue before your lordships. Now that if they are disqualified, to argue before your lordships, it will relate back to the day they incurred disqualification, and thus all their exercise of votes, including the floor test vote, will be annulled and is vitiated. All their exercise of votes, including the floor test vote. That's the argument being made before your lordships. That's the argument being made before your lordships. Now, my lords, your lordships have repeatedly, from Kuldeep Bishnoi, Pratap Gowda Patil, Shivraj Chauhan, Nabam Rebia, repeatedly reiterated that till a disqualification petition is pending, that an MLA has every or an MP has every right to participate, whether it's for a floor test, whether it's for a disqualification, for a removal of a speaker, or in a floor test, has every right to participate. Removal of a speaker. Now, if that is the law laid down by your lordships, how can it now be argued? And I showed my lords Shivraj Chauhan where exactly the same argument was made and rejected. And your lordships consciously talked about the 10th schedule being completely different from the other part. The two couldn't be mixed up from the other part. Now, the two couldn't be mixed up. Now, just come to that. Now, today, the same argument is being made to your lordships. So every bill, every apportionment, every decision taken will tomorrow every apportionment be annulled because as per them, tomorrow, the disqualification will relate back to the day you incurred it, and thus all decisions and participation in the House stand vitiated. To the day you incurred it, and thus all decisions and participation in the House stand vitiated. Which one? You show me that line. Which one? You show me that line. Now, my lords, Shivraj Singh Chauhan, your lordships had consciously said, and categorically said so, your lordships had consciously said that exercise of powers by the speaker to decide resignation or disqualification exists in a separate realm than a floor test. Exists in a then the reason I pointed out, because my Lord the Chief Justice had then said that could it be argued that that was the case only relating to resignation, and I respectfully submitted that no, your Lordships did consider the issue of disqualification in the matter and floor test. You can't let the two be interfered with. Now today your Lordships are repeatedly said thus because it would be vitiated. The whole thing is annulled, and I'll come in the end, my Lords. Lastly, to what all your Lordships are being asked to annul, that I'll come to as a consequence of once I complete all the acts which will flow in the waterfall as per them which will be annulled. All the acts which will flow because your Lordships order led to the toppling of a government, which of course is another argument which I'll deal with. Toppling of a government, which of course now, my Lords, is another argument which I'll deal with. Article 189 subclause 2. Article 189 subclause 2. Respectfully read out to my Lords. Also for the same proposition, read out to my Lords, that even if a person voted who was ineligible, the votes will be continued to be counted. Again, in furtherance of the same argument that I'm making, that I'm drawing sustenance from. Again, in furtherance of the same argument, my Lords, Article 190 subclause 3. Also, my Lords, read with Article 191. Subclause 3. Read with Article 191 says that vacancy arises when you incur disqualification. Says that vacancy and when do you incur disqualification? You incur disqualification either under Article 191(1) or 191(2), which is a 10th schedule. The Constitution does not say that the moment a disqualification is filed, a vacancy arises. That the moment a disqualification again an indicator of the fact that till a decision is taken on the disqualification. Again an indicator. How do you presume? And Manoj, the dangers of that is that we will have today constituencies unrepresented in Parliament and in the legislature because a disqualification petition is pending. In Parliament and that's in the legislature because a disqualification petition is pending. For a bedrock of democracy where every constituency ought to be represented in Parliament, for a bedrock of we are being today told that because a disqualification petition is pending, we should go unrepresented a constituency or should go unrepresented a constituency or
Mr. Call. In that case, suppose Speaker doesn't decide it for number of years. I got 6 months or 8 months like observed by Justice Nariman in the judgment. Correct? And what was observed by Justice Reyes Verma in that Coelho judgment. Correct? In between, correct? So many things happen. One thing, you can argue one thing, that whatever is in between decided on correct cannot be annulled. Correct, or cannot be reverted back. Correct, or cannot be recalled. But to say that the disqualification cannot be from the date on which the disqualification takes place will be there. Too much to argue.
Manoj, I did not for a minute. Your Lordships are absolutely right. I did not for a minute did not say that even. No. I'm not even saying that, my Lords, because today on that there is a complete answer in Rana. I'm not even saying that, my Lords. I'm just saying till the disqualification order is passed and MLA continues with all the vigor and robustness and legality at its command under the Constitution to exercise his rights as an MLA or an MP. I'm not for a minute suggesting that ultimately if it's held in his against him, it cannot relate back to the day he incurred disqualification. That's very different, as your Lordships rightly said, from in the meantime the actions which are taken. Because till then he is not disqualified. Till then there is no decision on it. Not disqualified. So that is why when I said it is prospective is in that context I said. That is why when I said when the order is passed, it may relate to events which occurred earlier. When the order is passed. The disqualification may be incurred on date A. The order of the speaker may be passed on date B, relying on an earlier event. Order of the speaker may be passed on. But that's quite different from saying that in the meantime, all that has been done gets wiped away. That is the submission I'm dealing with, my Lords. All that has been done, and if it gets wiped away, that is the submission I'm dealing with, my Lords. And if in Because that is why on the last date I respectfully pointed out, look at the danger of this to a democracy. A minority government can continue indefinitely by having all, whoever is inconvenient to them, filing disqualification petitions with no timeline of the speaker to decide. Whoever is inconvenient to them. Unlike the removal of a speaker, which I respectfully submitted, has a timeline. And that is why one of the concerns of your lordships in this matter and other matters has been that there should be a timeline to the speaker also deciding on disqualification. So conveniently there will be no floor test, or you will continue as a minority government, because whoever you feel will not vote with you, there will be a disqualification petition pending. Or as in Nabam Arabia, the Supreme Court dealt with and said that conveniently, because a speaker against whom a removal has been moved, you file disqualification petitions. Speaker against whom a removal has been moved, and none of them can vote. You file disqualification. Today, in any case, in each of these scenarios, your lordships have already held, it's no longer res integra. Whether it's a floor test, whether it is a resignation, whether it is a floor test, disqualification, anything. They said a member against whom a disqualification petition is pending participates. They said a member against whom a disqualification. So these issues have been considered by your lordships. And ex post facto, as used in Rana, can never be interpreted to me ex post facto as that MLA or MP ceases to exercise validly his rights as an elected representative of the people. It was in that context, my lords, that I pointed out it's a danger to the bedrock of democracy, that if a constituency goes unrepresented in the meantime, as far as a disqualification is concerned, my lords, that will ultimately can be rectified as far as a judicial review. But what happens if you keep holding on to it without a timeline? And that's a very legitimate concern that your lordships have expressed about, can a speaker hold on to it and not decide at all? And that is what Justice Nariman in that judgment expressed his concern with, and said that as the court understood it, expressed his concern that matter actually stood answered in Rana. Because in Rana, ultimately, my lords, what did the court do? When the reference came in some... Because in Rana, ultimately, my lords, what did the court Justice Nariman in the later judgment of 2020 considered the issue and said that the very fact that in Rana the court interfered, considered the issue and said that you should have only looked at and said the decision and the facts as they existed on that date and no subsequent amendment. There was already an exercise of judicial review of a timely action by the speaker. Because what was the import in Rana? The import in Rana was that the speaker ought to have decided on the date the disqualification was incurred, and there was no indicator of any split in the party on 6th of September on that day in that matter. So Justice Nariman said that the very import of that decision in Rana is that you should have taken a prompt decision which the speaker did not do, and thus the Supreme Court interfered in Rana. You should have taken a prompt decision in the manner. And then Justice Nariman went on to say that 3 months or 5 months would be an appropriate timeline. 3 months or 5 months would be an appropriate because the life of the legislature is 5 years. Because the life of the legislature is 5 years. And Manoj, if your lordships, that para has been read out to your lordships, if I just, for a minute, without even troubling your lordships, the lines used were, read out to your lordships, if I just, has clearly been answered, stating that a failure to exercise jurisdiction vested in a speaker cannot be covered by the shield contained in paragraph 6 of the 10th schedule, and that when a speaker refrains from deciding a petition within a reasonable time, there was clearly an error which attracted jurisdiction of the High Court in exercise of power of judiciary. Because the speaker then, without deciding on it, sitting on it, went on to decide something else, which was the split. And the court said that something else. Much later, you first decide on that particular day what happened. Much later. And in it, implicit was, the argument is, the court said in this matter, in this Megachandra Singh's matter, that implicit in it, in judicial review, was the fact that the speaker should have decided promptly. And the fact that speaker delayed that decision in Rana called for judicial review, and thus a time limit should be fixed. So my respectful submission on that would be, my lords, that even that very pertinent question of your lordships and that concern of a timeline today does stand answered in Megachandra. Today, irrespective of the Sammat Kumar reference, which has been made. And in fact, my lords, even Sammat Kumar reference, which has been made. And in fact, my lords, even Sampath Kumar, yeah, just. In fact, my lords, even in Sampath Kumar, I'm not, if your lordships want to see, I'm not bothering your lordships with the order. But even there, while referring it to a larger bench, because Quixote was there, the Supreme Court said that if a decision of a speaker is subject to judicial review, on disqualification, equally an indecision of the speaker would be subject to judicial review. An indecision of the speaker. So if a speaker decides to hold on, subject to judicial review, and not decide, an indecision is equally susceptible to judicial review as a decision. An indecision, even while referring it to the larger bench, because what was concerning the court was Quixote. Even while referring, and then the court in Megachand explained it to say that Quixote was in the context of interlocutory injunctions, in the context of quid timit action, which was not the case where a speaker indefinitely sits on something and doesn't decide it. And that has its own consequences in politics and a parliamentary democracy. And that has its own consequences in politics and a parliamentary democracy. My lords,
he referred it in December 16.
Please, my lords. My lords,
Nariman referred it in 2016.
Please, my lords.
For deciding this question, as he formulated, present petition raises a question of great constitutional importance, namely whether the Speaker of a legislative assembly acting under the powers granted to him under the 10th schedule of the Constitution can be ordered by the High Court exercising jurisdiction at 226 to decide a particular disqualification petition pending before him within a certain period of time. A particular disqualification directly the question pending before him within a certain period of time. But then he decided the question having referred directly December 16 and January 2020, Megachandra answers the question having referred in December. This reference is a two judgment. 2020, Megachandra answers the question.
And he, my lords, refers to the facts of Rana. And he, my lords, because in Rana, the facts were that the speaker failed to exercise some jurisdiction which he ought to have exercised on that day, and went ahead and recognized the split in the party, which he ought to have exercised on that day. And in that, Justice Nariman said, is implicit the fact that he ought to have decided that, and that decision itself, or indecision of not deciding, that and that decision itself, or indecision of not deciding.
Like Rana, correct? The court may interfere at the stage of disqualification. Otherwise, it is to be left to the speaker.
My lords, I'm very grateful, and my respectful submission on that is this, my lords. Firstly, that's what the Constitution provides for in terms of the scheme. These are coordinate constitutional authorities to whom your lordships have given equal deference and respect as they have given to this honorable lordship. And there are jurisdictions carved out where they must exercise their jurisdiction, and the court does not act as a court of first instance in these matters. There may be a rarest of rare case in these matters, where a term is coming to an end in 2 months, 3 months, and for 4 years it was pending in the High Court. A term is coming to an end in 2 months, and my lords, most importantly, in Rana, there was a decision of the Speaker ultimately. Most importantly, whether to remand or not was the case there, as far as the High Court was concerned, and then they said, let us decide it here. But that does not mean and cannot be stretched to an extent to say that your lordships will start deciding all this, you're to an extent. To say that your lordships will start deciding. Then, my lords, as far as the issue of the governor's exercise of power is concerned, my lords, my respectful submission was, my lords, there were 3 important facts, which were before the governor. 3 important facts, which were 1, before 7 independent MLAs withdrew support. 1. To the government. Independent MLAs withdrew support to the government.
Governor, Mr. Tushar Mehta.
Yeah, my lord, I'll just sum it up. I'll be the shortest on this point and then leave it to the learned solicitor. My lord, I'll just sum it up. I'll be the shortest. Yes, so one was 7 independent MLAs.
Just one second.
Yes, so one was 7 independent MLAs.
Just 1 second. Yes. What were you saying the governor had before him?
The cogent material, my lords, to call for a floor test is what your lordships are looking at. Was 7 independent MLAs withdrew support was to the government. 7 independent MLAs withdrew support. 34 Shiv Sena MLAs sent a resolution where the party, the political party, as per them, and the legislature party reflected on and said that there's huge discontent within the party for politically opposed ideologies, discontent within party workers, large section of the party, opposed ideologies, send that, and the faith in the coalition government was doubted, or questioned, send that, and any continuance of the coalition government was doubted. And thirdly, the leader of the opposition also notified the governor that the government in power did not enjoy the majority on the floor of the House. Now, my lords, in Bomai, on the floor of the House, your lordships have said, now, my lords, any material or any process or means, any material, of course it can't be extraneous, of course it can't be irrational, of course any material process or means can be used by the governor to come to the conclusion that a floor test is required. And the governor will not sit on his own and do a head counting in the Raj Bhavan. So the 2 or 3 principles which have emerged, my lords, is no head counting by the governor. So the 2 or 3 prima facie view based on cogent material by the governor. And floor test at the earliest, because floor test is the litmus test of democracy and should brook no delay, as your lordships have said. The litmus test of democracy and ordinarily do not give too much time to any political party, because then that whole problem of Aya Ram, Gaya Ram, horse trading starts. Now, what does the governor do in this case, my lord? A resolution with overwhelming members of the legislature party says that we have a problem with the coalition government. 7 independent MLAs say so in the case. Now, for him to tomorrow tell the chief minister to come and face the floor test, is this an exercise of his power without any material? So arbitrary, is this an exercise of his power without, if at all, it can be argued that it's arbitrary, that your lordships will exercise your lordships' extraordinary jurisdiction to interfere with it. Or it's a plausible view that the governor could have taken in the facts of the case. If it's a plausible view that the governor could have taken in the facts of the case, and to say, my lords, another argument was made was that he should have asked for a no confidence. But my lords, there's nothing in the constitution. Incumbent governments have been asked to face protest, as we showed to your lordships in judgment. So to say it's never happened is wrong, as we showed to your lordships in judgment. And where is this rule that you should only ask the leader of the opposition or any other person to move a motion of no confidence? There is no legal prohibition. In fact, I would go to the extent of saying, my lords, if the governor is satisfied that a government has lost the majority on the floor of the House, it is the duty of the governor to call for a floor test at the earliest. And not indulge in indulge in head counting sitting in the Raj Bhavan. And that's all that he did. And the day he does it, a petition is filed. And that's all that he did. And the day he does it, a petition is filed.
Exercised by a governor in some recent examples that we have
seen. Well, I'll find out. That's a.
It was the duty of the governor.
I will. But may I only answer that by saying 2 things? Well, I will. No, one I'll give that. I'll just find that out. But I take it for a minute. I'll give that. I take it for a minute. But it had never happened before. I take it for a minute. So what? If a governor is within his powers to do what he is doing, and there is no prohibition to what he is doing, he is not bound by just precedents. The law, Bomai says, any process or means and material. Now, if material is before the governor to come to this informed decision, what is wrong with it? Material is before the governor to come to this informed decision. What is wrong with it?
Use of power.
That, my lords, in every case will see.
You are saying speaker's decisions.
That, my lords, in every case will see.
As you said, having acted or not acted.
And
both ways.
And then that is why I said what is to be seen is the material before him.
Both ways.
And if according to us, if 7 independent MLAs, if according to 34 or 51 MLAs with a resolution saying that we don't want to continue, 34 what better indicator? The resolution
that a government does not enjoy the majority on the floor of the House ultimately. Now, again, the governor is not going to embark on the inquiry which the Election Commission embarks on. The problem here is that the Speaker is being asked to embark on the inquiry which Election Commission embarks on. The governor is expected to embark on an inquiry which the Election Commission embarks on. Governor will look at the material placed before him, which is an overwhelming number of MPs who have been supporting the government earlier, right to say we don't support the government. He doesn't call upon and swear in anyone else into power. He asks you to face the floor test, and you know you don't have the majority. The moment you don't get the stay, you resign within 10 minutes of that order, which came that night. Within 10 minutes, you had resigned because you knew you did not enjoy the majority on the floor of the House. He did not directly swear in someone. Now, after that, if a coalition comes before him and says that he wants to stake our claim, and a coalition which actually was a pre-poll alliance earlier, what is wrong with it? Claim and a coalition which actually was a pre-poll. Now, my lords, what is wrong with it? The next point for your lordship's kind consideration now, my lords, that your lordship's order led to the toppling of the government. That your lordship's order led to the toppling of the government. All that your lordships did on 27th was firstly extend the time. All that your lordships did because the action of the Speaker was in gross violation of the most elementary principles of natural justice. Contrary to the Maharashtra Legislative Assembly rules of natural justice, giving 2 days on a weekend to file our reply. Giving 2 days on a weekend. We did argue Nabam, I've repeatedly said. We did argue natural justice and we did argue threat to life. The court extended the time and also said protection to their life to be given. And also said protection to their Now, I go a step further, my lords. Suppose the court had relied and incorporated the Nabam principle in its order. Suppose the court had relied and incorporated what is wrong with it? Nabam till date holds the judicial field. Nabam is the law of the land. It's a constitution bench of this country. Of the Supreme Court holding the decision. It's a constitution bench of this country. So if it had relied on Nabam also, there was nothing wrong with it. It was fully within its power and justified to use and rely on Nabam. There was nothing wrong with it. It was fully within its power. And then to say that a government came to be toppled. Because after that, because we are given more time, and the governor asks you to face the floor test. And you resign because the stay is not granted by the Supreme Court. You say your lordship's order of 27 toppled the government is not granted by the Supreme Court. Because your lordships had given more time, because had that time not been given, then the disqualification was per se would have been incurred in the meantime. That's the convoluted argument being made before your lordships. That can never be so. That's the convoluted argument being made before your lordships. Then, my lords, that can never be so. Then, my lords, came the 29th order. Now, 29th order, my lords, when they came and said, apart from the fact that it said, subject to the proceedings on trust vote on 30th of June 2022. Proceedings on trust vote on 30th of June 2022. We argued that a floor test brooks no delay ought to be occurred at the earliest. We argued. In fact, the words used in Bumai are that a chief minister, the words used in Bumai are a chief minister cannot shirk his responsibility to face a floor test. And if he refuses or shies away from a floor test, it's a prima facie view that he's not confident that he enjoys the majority in the House. So what did the governor do? Said face a floor test. The Supreme Court said, how can we stay a floor test? What did the governor do? Because we keep coming back round and round to the same argument. Had disqualification been decided, had time not been given, then this would not have gone through. That's not the way. Had time not been given. Firstly, a speaker will have to take a decision, and I came on principles of natural justice. The court said give them more time. How can you say a court order led to toppling of a government? The court said give them more time. And the 29th order specifically said that the proceedings of 30th are subject to court proceedings, but nothing happened because the chief minister had resigned. After that, fresh floor test was held a few days later, where overwhelmingly the new government and the new speaker were sworn in. A few days later, where overwhelmingly the new government and the new speaker were sworn in. My lords, the EC issue I'm not touching on, that 18th meeting relied on
27, that is wrong. They were independent meetings, and I haven't really gotten into the EC issues because your lordship had so indicated. And we have right through said that all this had started on 21st, which was really a culmination of the dissent, brewing for a long time and ultimately culminated in that resolution on that day. And at appropriate times on 25th and 30th, when it suited them, they wrote to the same election commission and then came before your lordships to say that no, stay. The election commission should not exercise its jurisdiction. And then came before your lordships as far as the election commission should not exercise its jurisdiction. My lords, as far as the NABAM, this one. My lords, as far as the NABAM issue is concerned, my lords, again, that is something that I don't need to give address to your lordships extensively on. And the principal concern, my lords, there was one, and especially when para 1338 onwards and Justice Mishra dealt with it, was that constitutional proprietary demands that after the introduction of the 10th schedule, if that after the speaker within the period of the notice and the date when it's actually held alters the pool, what happens? And they relied on what? And the Constituent Assembly debates, including Dr. Ambedkar's reference to the 179C of the then members. The then member argument, my lords, even then emphasized on not just present on voting, but the emphasis was on the pool of the House. Now that is the exact principle which NABAM also follows. That if between the day of the notice to the date when the resolution is moved, if you alter the pool, you do not then reflect the correct composition of the House, because you have altered it in a manner to suit yourself. And there is a conflict of interest as far as that is concerned. An argument which was sought to be then made was that Article 181 provides that the Speaker cannot preside over the House only on the day of the resolution of the removal of the Speaker and not from the date of his removal as communicated. That was the argument on 181 made. And not what is 181? 181 is also an argument to say that you cannot be judge in your own cause. You should not on that day, for instance, not count certain votes, carry it out in a manner. The very principle of 181 is what is also applied. If at all 181 serves my argument, furthers my arguments, because what NABAM says is that given the introduction of the 10th schedule, there would be a clear conflict of interest. And in any case, there's a timeline provided therein. Within that, you decide your removal within the timeline provided, and then go ahead and uses the word that if a speaker is confident, he can continue. But the danger, the flip side to it is, my lord, a speaker's election, if he proves his majority, is not questionable. But what is questionable is a disqualification at the end of the day. So they said that in a matter like this, first show your majority and then continue with it. So to say that the Constituent Assembly debates were to the contrary is wrong. Even in the Constituent Assembly debates, firstly they were dealing with the removal of the Vice President. And other issues, they weren't dealing with 10th schedule at all. There was no 10th schedule at that stage. The then members was interpreted in the context and to say that the House composition on the day the resolution is moved is in that context. To read on the day the resolution is moved is in that context. Resolution is moved, and in NABAM the court was wrong in reading it from the day of the notice is completely wrong. Because if the court doesn't read it the way the court has read, as the court has said that this would have led in a matter like this to sustain a robust vitality of the growing constitution were the words used and to avoid any conflict of interest. This would be the most appropriate constitutional and ethical argument to tell the speaker to do it in a time-bound manner as far as you are concerned and then go ahead with it. So my respectful submission is, my lords, and then go ahead with it. NABAM requires no reference, lays down the correct law, requires no reference to a bench. Now, lastly, my case law note is already with your lordships on each of the propositions I have given. My case law note is already with your lordships on each of the propositions I have given. So, my lords, effectively, everything that is annulled is their argument. Effectively, everything that is annulled, then Mr. Thackeray's voluntary resignation should not have been accepted because he resigned. He should not be. They should have continued. Resignation should not have been accepted. The governor should not have acted in his constitutional capacity to invite the largest party as it then saw, or the coalition, to come and form a government. The confidence motion in the House reiterating overwhelmingly the faith in the new government and the new speaker needs to be reversed. Reiterating overwhelmingly the faith in the new government and the new speaker. The governor ought not to have administered the oath of office to Mr. Shinde. The speaker ought not to have been elected by the House not once. Confidence reinforced in him again. The speaker ought not to have been elected by the House not once. So everything needs to be annulled because everything relates back to that one day when disqualification was incurred, and because the speaker was not, or the deputy speaker was not allowed to decide that, and everything that has happened is vitiated. And in the process, whether you refuse to face the floor test, that has happened is vitiated. You did not have the confidence of the House is all immaterial. And a government which overwhelmingly proves its majority, everything should be annulled. And despite all the law that your lordships have laid down, that every member is entitled to vote on the floor of the House, irrespective of the disqualification pending, should all be ignored. Manoj, in Navam, I must also lastly point out to your lordships, subject to correction, I am instructed to say that apparently a review was also filed against the judgment in Nabam, raising the same grounds of challenge against the judgment in Nabam, raising the same grounds of challenge. And it also raises the same interpretation of all the then members to be the date on which the vote takes place. The same interpretation of all the then and members the Article 181 argument. And that review was also dismissed. The Article 181 argument. And now, my lords, is it fair to re-agitate the same issue all over again now, my lords, before another constitution bench is another argument the same issue for your lordships all over again consideration? My lords, I am extremely grateful. Your lordships are kind enough to call upon me again. I am very grateful for that. Thank you, extremely grateful. Your lordships are kind enough to call upon me again. I am very grateful for that. Thank you, Mr. I am very grateful. Mr. Jethani.
I have a note, which is note K in your lordship's record.
Jetmalani, we have 44 files on PDF, all part of the written compiling.
I empathize with your lordship's.
All part of the written compiling. Written on
I empathize with your lordship's.
Last one. Written on 17 pages. Last one. 17 pages?
But there's no PDF. I'm told there's no PDF.
17 pages. 17 pages?
But there's no PDF. I'm told there's no PDF.
17 pages. 17.
It's a separate document.
It's a 7-page document.
It's a separate document marked note K.
It's a 7-page document.
I would, it's a separate document marked note saving time. I would run through that note a little bit so if your lordships could have it. Saving time, I would run through that note a little bit so if your lordships could have it. Lordships got it?
I think we can run through the 7.
I beg your pardon.
I think we can run through the 17 pages.
I beg your pardon. But it'll be difficult. It'll be a spillover. But it'll be difficult. It'll be a spillover.
ये मुझे में नहीं है डाउनलोड कर देंगे ये मुझे में नहीं है डाउनलोड कर देंगे
No, it's tried to state that every case depends to a large extent on its own facts. Every case, my learned friends, to a large extent on its own facts, have taken recourse to some facts. My learned friends, but I propose to deal taken recourse to some facts, more substantially with facts, and only incidentally with the law, because a lot has been said on the law. More substantially with facts, and to point out, Manoj, that the fundamental propositions of law which my learned friends have raised in this case, point out, Manoj, that the fundamental on the facts of this case don't arise at all. But Mr. Salve has said something on it. Of this case don't arise at all in his brief submission. I'll just expand a little on it. Something on it. But essentially, the 2 points of law, as I understand it, in sum and substance, what it boils down to 2 points of law is A, the question of sum and substance deemed disqualification. But to use that term which is sometimes used and sometimes steered away from. But to use that the question of deemed disqualification, i.e., they were liable to disqualification. The question of deemed disqualification, i.e., they were liable. Disqualification never took actual place, but they were liable to be disqualified. Disqualification never took actual place. And consequently, as a result of that deemed disqualification, and the second proposition of law, and that is that the court must set the clock back, relying mainly on Rana, again, extensively dealt with by my learned friends, Mr. Salve and Mr. Kaul, and set the clock back completely, because the concept of deemed disqualification, since it dates to the date when the acts entailing disqualification took place, since it dates to the date when the acts entailing disqualification are the ones that are relevant for the purpose of disqualification. So you must look at that time. Are the ones that are relevant a brief conspectus of facts. So you must look at that time. As I pointed out earlier, when you're dealing with referral, there's a very short time span, and that's between 21st and the 4th. There's a very short time span, and that's it's important to note and the 4th. That while discontentment and division commence from the very inception of the post-poll alliance of the MVA government, from the very inception of the commencement of irreconcilable differences occurred on 21st June. That's the first day. Commencement of irreconcilable differences chiefly centered around the disinclination to continue with the MVA alliance, which as per the Eknath Group, was causing serious turbulence among party cadres for 2 reasons. The Shiv Sena had entered into a pre-poll alliance with the BJP for the elections held in November 2019, and their voters and cadres were aggrieved by the betrayal of that pre-poll alliance by the constitution of the MVA coalition government, and 2, that the party cadres were finding it difficult to reconcile long-standing ideological battles with their coalition partners, namely the Congress and the NCP, and the cadres of the different party in the coalition, far from working in cohesion, but at loggerheads with one another. Now, there are many statements even before the 21st. Ministers of the then Shiv Sena, the joint Shiv Sena, many statements. Ministers of expressing dissatisfaction in public. Many statements. MLAs have complained about it. So this is all. 2021st is the only date which this record, which this court has a record of. 2021st is the only. But it happened much earlier. Record with which this court has a record of. But the first steps. But it happened much as per the record of this court, that led to the rendering the differences irreconcilable, as per the record admittedly initiated by the Uddhav Thackeray Group. But the first salvo was filed on 21st June by the Uddhav Thackeray Group. In its resolution of 21st June 2022, A minority of members of the Shiv Sena Legislative Party in the Assembly removed Eknath Shinde from the post of Group of Shiv Sena Legislative Party, of leader of the Shiv Sena Legislative Party. On the same day, the Chief Whip, one Sunil Prabhu, issued a party whip summoning all members of the Shiv Sena Legislative Party to attend the meeting at the CM's residence on the same day. To attend the meeting. The removal of Eknath Shinde. Well, this is where it starts because my Lord Justice Kohli was asking about could there be no reconciliation? Was there no party forum to resolve these differences? Could there be no the first salvo that was filed was on 21st June and it was a very drastic salvo filed. The salvo was you remove it as a legislative leader. After that it became very concise. Nothing could be done. And I'll tell your Lordship what happened afterwards. Those facts are very important as to why the party forums became irrelevant. What was done by the party organization and the party leaders, including people in Parliament, the party leaders in Parliament, and the party leaders, including people in Parliament. The removal of Eknath Shinde as a leader of the legislative party indicated an intention on the part of the Uddhav Thackeray faction to escalate a simmering dispute to a point of no return. Neither the resolution nor the whip issued by the Chief Whip were communicated to any of the Shiv Sena MLAs who were not signatories to the resolution. Eknath Shinde and the other MLAs only learned about the resolution and the whip on 21st June through media reports of the same day. On its part, the Eknath Shinde group consisting of 34 MLAs passed a resolution on the same day setting out various grievances with the party leadership for forming the NDA government and the impact that it had on the party, its organization, cadre and voters. Now, not all this has been read, so I'm not going to read in detail. But your Lordships will recall that the letter of 21st June was a response by Eknath Shinde to his removal, in which he pointed out that it was not just the legislators, but it was also the cadres who were disappointed. So the organizational disappointment along with the legislator disappointment were both highlighted in that letter of 21st June, which as I said was a response to their letter. In that letter of 21st June, which as I said was a response. By the resolution, 34 MLAs reaffirmed Shinde as the leader of the Shiv Sena Legislative Party, removed Sunil Prabhu as the Chief Whip with immediate effect, and appointed Mr. Bharat Gogable as Chief Whip in his place. The resolution was sent, this is important, my Lord, the resolution was sent and received by the Governor of Maharashtra. So the Governor of Maharashtra, to answer again, my Lord Justice Kohli, had his first intimation of a simmering dispute on the 21st June. The resolution was sent and received by the Governor of Maharashtra, the Deputy Speaker of the Legislative Assembly, and the Secretary of the Maharashtra Legislative Assembly, both by email and a hard copy. The 34 MLAs on the same day, we are still on 21st June, also sent a notice to the Deputy Speaker, Mr. Zirwal, of intention to move a resolution for his removal under Article 179C of the Constitution, read with Rule 11 of the Maharashtra Assembly rules. I'll read those rules in a minute, because they are quite important. They deal with the 14-day period notice prior to consideration. 14-day period and the rule and the article are both mentioned in that letter sent to the Governor and the Deputy Speaker. And the article are both mentioned in that letter. On the ground that he no longer enjoys the support of the majority of the House and accordingly has lost his right to continue as Deputy Speaker. In view of the decision in Navam Rebia, the Deputy Speaker was requested to refrain from acting as Deputy Speaker till such time as he could prove the support of the majority in the House. As he could prove the support of the majority. What are the contentions of the petitioner? First, that if the respondent had a grievance with the party leadership, he ought to have sorted it out within the party and not sent the notice under Article 179C to the Deputy Speaker. That the notice of the Deputy Speaker was flawed because in any event, the Deputy Speaker's disability under Article 181 commenced on the consideration of the notice of a resolution of removal and not when notice had been given of the intention to move the resolution under Article 179C. The decision of Navam Rebia to the contrary needed reconsideration. And the resolution of 34 MLAs of Eknath Shinde group was without jurisdiction, as Eknath Shinde has been removed as the leader of the legislative party in the House. That's by their letter of 21st June. As the leader of the legislative party in the House. This is the response of the. As regards the reply to 2-1 above, the question of resolving grievances against the leadership within the party did not arise, as the party leadership had precipitated the issue and made any reconciliation impossible by unilaterally and illegally removing Eknath Shinde as leader of the legislative party. Well, no hearing, no notice, nothing. This unilateral removal had to be viewed as a hostile act, which would be followed by more serious consequences. In the circumstances, the letter to the Deputy Speaker under Article 179C was a protective step against any escalation by the Uddhav Thackeray group. Significantly, at this stage, now this is important, the Eknath Shinde group did not take any steps in the direction of unsettling the government by withdrawal of its support, necessitating a floor test. By withdrawal of its support, on the applicability of Nabam Rabia. But although on facts, it's my respectful submission that Nabam Rabia's, the case doesn't arise at all. On the facts of this case, nevertheless, my lord, if your lordship do intend to say something about Nabam Rabia, it is my respectful submission that it should be to reaffirm, especially Justice Mitra's view. My lord, I concede that the then member's part of 179C has been wrongly construed, particularly in view of the Constituent Assembly debates, and particularly the view of Dr. Ambedkar in that. But my lord, there's much more to be said apart from the then member's part of it. For reaffirming Justice Mitra's very eloquently put view in that separate judgment. Justice Mitra's very eloquently put view in that. On the applicability of Nabam Rabia, the construction of that judgment regarding the time when the Speaker's disability under Article 181 commences was established law by a constitution bench, and the Deputy Speaker was bound to act according to its dictates. But that's an aside. In any event, whether you like Nabam Rabia or not, the Deputy Speaker was bound by its mandate. And its disobedience at that particular point of time is a serious breach on his part of his duties. And the role envisaged for him by the Constitution, impartiality, and of course obedience to the law. And the role envisaged for him by the Constitution. As regards the correctness of the view taken on this aspect in the decision in the Rabia, it is respectfully submitted that this honourable court should reaffirm the view in Nabam, most emphatically enunciated by Justice Mishra, that when there is an expression of intention to move a resolution. Well, may I just read paragraphs 236 and 238 of Justice Mishra, just 3 paragraphs at this stage. It's PDF 1167. Just 3 paragraphs at this stage. It's because he makes the case for what he says compelling. Because he makes the case for what he says compelling. 236. 236. In this regard, Lordship's Government, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers of the Speaker. While deliberating on the constitutionality of said schedule, the majority in Kyoto's case has stated the Speaker Chairman, while exercising powers and discharging functions under the 10th schedule, act as tribunal adjudicating rights and obligations under the 10th schedule, and that decisions in that capacity are amenable to judicial review. However, having regard to the constitutional scheme of the 10th schedule, judicial review should not cover any stage prior to the making of a decision by the Speaker's chairman. Having regard to the constitutional intendment and the status of the depository of adjudicatory power, no quia timet injunction actions are permissible. Now, I'm not pausing there for a minute. No quia timet. If there is a constitutional violation by the Speaker, the actual order of disqualification, that is not contemplated by Kyoto's judgment. For instance, when he did not comply with the notice period, for instance, and that notice period is under Rule 8 of the 10th schedule, and that notice period a court could intervene. Because that was a denial not only of natural justice, a court could intervene, but a contradiction of the rules framed by them in their wisdom. But under Rule 8, under Clause 8 of the 10th schedule. And Kyoto says something about the sanctity of those rules. I'll come to that later. Kyoto says something about the sanctity of para 6.1 of the 10th schedule, to the extent it seeks to impart finality of decision of the Speaker's chairman is valid. But the concept of statutory finality embodied in paragraph 6.1 does not detract from the aggregate judicial review under Articles 136, 226, 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafide, non-compliance with rules of justice and perversity are concerned. But Kyoto says more on paragraph 8 rules. And I'll come to that. On the rest of that, and I'll come to that, is, Your Lordship may just see J. That contention that the investiture of adjudicatory function of the Speaker's chairman would by itself vitiate the provisional ground of likelihood of political bias is unsound and is rejected. The Speaker chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and do take far-reaching decisions in the functioning of parliamentary democracy. Vestiture of power to adjudicate questions under the 10th schedule in such constitutional functioning should not be considered exceptional. Now comes justice. Constitutional functioning should not be considered exceptionally. On enunciation. Now comes justice. The aforesaid reasoning eloquently speaks of the power, position, and the status the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and restricted it to the stage, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority stroke jurisdiction, exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional values sustain democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. My Lord, when I show the facts of this case as subsequently transpired, I will show Your Lordship that the Speaker repeatedly violated his constitutional duty as envisaged. Violated his constitutional duty. The Speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible.